Appellate Division 4 Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. So, before we begin our calendar today, I would like to welcome, I think we have 20 candidates who will be sworn in this morning as attorneys and counselors at law. And I see that many of them may have families, friends, and others here present with them. So welcome all to our courtroom, and to those that are watching over our live stream. This is quite an event, and it's appropriate that you all be here and viewing us to celebrate this achievement with them. So welcome all. To our candidates, I congratulate you on your hard work and determination. You have much to be proud of in having persevered to reach this milestone in your career. Ann Dillon Flynn, the clerk of our court, will administer the oath of office. Ms. Dillon Flynn, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law?
Yes, Your Honor, they have.
Please administer the oath.
Raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New York,
and the Constitution of the State of New York,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of an attorney and counselor at law
of an attorney and counselor at law
according to the best of my ability.
according to the best of my ability.
Congratulations.
Congratulations, counselors. How's that sound? Pretty good? I wish you nothing but great success in your careers, and I trust you will find, as I have found, and I'm sure as my colleagues have found, that this is really a unique opportunity for you to enter the lives of clients at points in time where they are at their very worst sometimes, and emotions and anxiety are riding high, and it's going to be your job to go into their lives, to make their lives better, and to show them a path where there's a light at the end of the tunnel. And so it's a great gift that you've just received, and I'm certain that you're going to use it well, and I wish you nothing but success. Thank you. We're going to wait just a few minutes until everybody clears out of the courtroom, and we'll get started with the calendar. I'm always looking out for them. Chris? Let's put that. Yeah, that's nice. The first case on for argument today is case 340, People versus Boatwright. Counsel, proceed.
Good morning, Your Honors. Kathy Reardon on behalf of Delvin Boatwright. Your Honors, going to be relying on our brief this morning unless the court has any questions.
No question. Thank you, counsel.
Good morning, Virginia Harper for the People. Unless the court has any questions, I will also rely on my brief.
No questions, counsel. Thank you.
Thank you.
Case 341, People versus Evans. Counsel, can you hear us?
I can, Your Honor.
We can hear you very well. Thank you. Please proceed.
May it please the court, Lyle Hoydu assigned counsel for Jason Evans, who's appealing his conviction for burglary and robbery, where he received 20 years. In our brief, we raised 3 points, Your Honor. I'm just going to focus really on challenging the proof that came in. I would note in this case, there was no objective evidence, meaning no fingerprints, no DNA, no forensic evidence linking the defendant to the crime charged. The case rested primarily on the testimony of a 73-year-old homeowner, primary witness. When that witness was in the courtroom, presumably seated right in front of the defense table, he was unable to accurately describe the defendant. Despite the best efforts of coaxing him, he could not accurately identify a piece of clothing or any type of color that he was wearing. And yet, this same 73-year-old witness, when shown grainy videos, either from the neighborhood or from a store, claims that he can identify the defendant as appearing in those videos. And what's incredible about that, Your Honor, is that the police looked at those videos and the neighbors looked at those videos, and they all agreed that it was impossible to identify anyone because of the poor quality. I would note that this witness, when the police intervened, he was unable to give an objective description, meaning the height, the weight, clothing, tattoos, anything that would allow for an objective description of the intruder. And in fact, in this case, we know that the intruders were wearing masks, so their faces were completely covered. The second intruder, which he claimed was the defendant, never spoke. And when he was confronted with this on cross-examination, he said his ID was based upon the way that the defendant moved and how he knelt. But he never gave a description of what he meant. There was no unique limp that he claimed that the intruder had, or a unique gait or anything of the sort. So what we're left with is a 73-year-old homeowner who was terribly injured and beaten but he's speculating as to who did it to him. The other challenge I'd like to note, Your Honors, is they allowed expert testimony from an FBI agent. And the FBI agent offered an opinion about the geolocation of a cell phone, and he did it predicated upon data that came from Google. The problem was he never established the reliability of the data upon which he was basing his opinion. And he never claimed to understand the Google algorithm. He never had the training from Google. He had no knowledge of an error rate. And that's a requirement in order for him to rely upon that data to give an expert opinion. The data has to be demonstrated as to what the rate of error is. And to this day, we don't know whether Google's data has an error rate of 20 or 30. No one knows because the expert never testified to that. And our argument is that was his burden to establish, and because of that, his opinion should have never come in.
We'll take a look at that, counsel.
Appreciate it, Your Honor. Thank you.
Thank you.
Good morning, Your Honors. May it please the court.
Good morning.
Mindy Van Leeuwen for the people. First of all, while the defense counsel in this case says there's no objective evidence, what about the car itself? The car is objective, credible evidence that these two individuals could have been there, right? It's on 3 different surveillance cameras. It is directly traced back to the co-defendant's girlfriend. Okay, so that's 1. 2, found in the car were the phones. One of them is actually registered to the defendant himself, Jason Evans. His email's on that phone. Are there other things on that phone? Yes, but his voice messages, his text messages, pictures of some of the stolen jewelry, specifically a stolen ring, are on this phone.
Some Google searches about the jewelry and what was taken from the house in terms of
the
value of those things and how to determine whether or not a Rolex is a fraudulent Rolex or not.
Exactly.
Yeah.
So we have a lot of objective, credible evidence. So the people would disagree with that claim. The receipt was very telling. This was a receipt from the Dollar Tree that was closest to the victim's house. That was, the items were purchased less than an hour before the actual criminal transaction took place.
Let me go back to one thing your opponent indicated, that during the trial, there was an attempt to identify the defendant. And there was some indication in the transcript that there was some confusion about that, and counsel's pointing that out. Counsel says that he wasn't able to identify him. Is that your position, to agree that the defendant was not identified in court?
I absolutely disagree, as well as the court in that case. The court actually said to, I believe, Ms. Altucher, defense counsel in this case, she was misrepresenting what had happened at that time, and that the record shall reflect that the witness did identify the defendant here.
He identified him as wearing glasses and sitting next to a female lawyer.
Correct.
Is that
And there
right?
was only one female attorney, and he was wearing glasses at the time. I would also say that Mr. Laporta was not our star witness. He's the victim in this case for sure, but he didn't actually identify the defendant as the perpetrator here. The data did.
Right. Before you go on further, there's something you mentioned right away that I missed until I just caught it in the record. His phone, the Samsung phone, I have that as recovered from the vehicle in which he was arrested, not the Mazda. Is that wrong?
No, that's correct. Jason Evans, there was a separate cell phone, I believe, is registered to Caitlin Nielsen that we believe Mark Shadow was using.
Right.
That's correct. Yes.
But we're not talking about the co-defendant, we're talking about the defendant here. And it was my understanding on that phone, and no doubt, we have the searches and the address of at least the street address of where the victim is, but that phone also had some indication that the brother and then another individual had been using.
At one point or another, but it was registered to the defendant himself. The main email on the phone, when you open your email account for the browser or whatever for it, was Jason Evans. And also his voice messages, his text messages. He actually had some, you can record a voice message. There's a recorded voice message that was put into evidence too, that was of his voice that they identified as him, besides photos of himself, selfies as well. So it was overall identified as a defendant. Do I use my husband's phone sometimes? Yes. But is it still his phone? It is.
And as far as the brother and this other individual, Mr. Jones, perhaps, is there any indication on the phone as to when they may have been using it?
I'm sure there was, but I don't believe that was entered into evidence, Your Honor. So I couldn't speak to that. I'm not sure if that's part of the record. What is part of the record, though, and one thing that that defense counsel brought up was that Mr. Jeremy, the twin, wasn't investigated. He was investigated. His phone records were actually ordered. They also did what's called an ECAC packet, or Erie County Crime Analysis packet, on him as well, to see what was registered, what phones, what was registered to him, who his associates were, all those different things. And none of those matched up with Jeremy's phone being Jason's. Jason's phone was identified as his, and Jeremy's cell phone records identified that as his phone. So it is part of the record that Jeremy's cell phone records were run and that he had his own phone. So he was vetted. He had an alibi. I don't know if the alibi was fully vetted, but they did investigate him and ordered his cell phone records. With regards to Mr. Laporta, though, it helps that he says that one of the first things he says is, I think it was Jason Evans that did this, when the officers asked, right? A couple of minutes after the officers asked. Did he identify him as the perpetrator in court? No, he just identified him as, that is Jason Evans, not Jeremy Evans, which is also helpful, right?
And he did that based upon some experience that he had with the defendant over a period of time?
That's correct, Your Honor. The defendant worked for him for, I think he had known him most of his life. I think he said something like 30 years or something like that. And he owned a company in which the defendant would roof for him. So he moved around and kneeled, and he said, after years of experience of watching this person with their special gait move around and kneel, I can tell you that was probably Jason Evans. Now, he's not seeing him in court move around and kneel, so he's not going to say that's the intruder. He said, that is Jason Evans. I recognize him as Jason Evans. And he also had mentioned a couple different details about, one has a more slim face, one has a more full face, and things like that, about how he could tell these identical twins apart. So, Your Honor, with regards to, if I can, we believe that there's more than sufficient evidence between all of the things combined here. Most importantly, of course, was the cell phone data. Now, even without the geolocation Google map data, these individuals' phones were co-locating to Wi-Fi signals that were next to the victim's house at the time of the crime as well. They were co-locating to Wi-Fi signals next to the Dollar Tree at the same time of this. So we know from an abundance of data with regards to these things that these individuals were the two people there at the time of the crime. We see them go in, we see them go out, we see them get into this car that's linked to this. So there's an abundance of evidence over and above the geolocation data. We would also say, though, that the lower court did not err in entering these things into evidence, is because the reliability of the maps themselves go to weight and not admissibility. This person was properly qualified as an expert. He's one of 15 special team members in the entire United States that have special training on this CAST team. If anybody, I think he has to be the one to be able to be qualified to say this. He did say he has special training from Google. It was part of his CAST recertification, is what he says during the questioning. So it's not saying I didn't receive it. I did receive special training from Google. And the thing I don't really understand about
And he was subject to cross-examination with respect to his qualifications and how he came to his conclusions. And your argument is that all goes to the weight that the jury could fairly evaluate.
And that's how the court ruled as well. They said this particular issue goes to weight and not admissibility. Now, the attorney did not actually argue against entering him as an expert with regards to the cell phone tower data itself, with regards to basically anything else, right? So all of the other things that he testified to with regards to those cell phones also comes in. And so with this one point, so he's saying the rate of error, so you can't pinpoint someone precisely because, as he kind of described it, the two cell phone towers, let's just say there's two there. If the person's in the center of it, it's like a sprinkler system. The data tries to come out as best it can, and they think it's around this point. So the rate of error is actually the radius itself. It's not saying he's on 10th Street at 3 p.m. It's saying he's between these two towers at 3 p.m. So he's saying that's the rate of error. So it actually took a couple times when the defense attorney was asking him during cross-examination, what do you mean by rate of error? Because that can mean multiple things. And I think what really came down, what I think that person was arguing was that the Google data itself of the location, not the towers, because she didn't object to that, but the data itself, somehow, maybe the maps was off, but that's what I didn't understand. So I think it's even a more micro argument than we think it is, because they're not objecting to the maps themselves. They're not objecting to the cell phone tower data. She specifically says, I'm not objecting to the cell phone tower data itself. It's just the rate of error of the algorithm, but the algorithm of what was never fully explained. So I think this is a menial error. There's, if any, we don't believe it's an error. If anything, it goes to weight, not admissibility. And specifically, the FBI expert witness testified regarding the margin of error, so his testimony could not have been seen as impermissibly speculative or unreliable. There's no further questions, Your Honors. I'll rest the mic.
No further questions, counsel. Thank
Thank
you.
you, Your Honor.
Case 342, People versus Fleming. Proceed, counsel.
Good morning, and may it please the court. My name is Aaron Friedman, and I'm appearing on behalf of Keith Fleming. I'll be focusing on point 1 this morning, which is that Mr. Fleming was denied his right to a jury selected in accordance with the law when the trial court followed this court's 2018 decision in People v. Conway to dismiss a sworn juror as unavailable because it had concerns that there might not be enough certified sign language interpreters available throughout the duration of the trial.
Mr. Friedman, good morning.
Good morning.
I focus on the way you just phrased that, the right that the defendant had. I don't think the defendant doesn't have a right to this particular juror, correct? The defendant, as I understand it, and then I'll give you a chance to respond. The defendant has a right to make sure that he or she participates in the process of selecting or deselecting the jury. That's really the fundamental right here, which goes to the right to a fair trial, I suppose. But in terms of the right to have this juror, this deaf juror, continue to serve as a sworn juror, that the right we're really looking at is the participation of the client in jury selection, isn't it?
Well, I think I would agree with Your Honor that a defendant doesn't have a right to any particular jurors. The defendant, I believe, does have a right to those jurors not being removed from the panel or not being removed from the jury, in this case, a sworn juror, unless there is a legal basis, unless the court has authority to do so. So I would point Your Honor to this court's 1985 decision in People v. Wilson. And in that case, the court emphasizes that there's a distinction between 270.35 and 270.15. And the court frames this in terms of the trial court can't remove a juror unless it has a particular statutory basis to do so. And in that case, it would have been 270.15. And similar to this case, the court dismissed a juror as unavailable rather than unable to serve, which would have been the appropriate standard. So not only do 270.15 and 270.35 clearly impose different statutes, the language of the text is quite clear, but this court has so held for the last 40 years.
Capacity, right?
Ability versus availability, correct.
The motion below is for mistrial. So the request below was, Judge, not that you keep juror number 5, but you remove jurors 1 through 4 as well. We mistried. We let everybody go. I don't know what that would have done in terms of a panel, if you could start again anew, or if they would have needed a new panel, but that was the request below, right?
So the way that I review the transcript, I see 3 separate requests. First is the mistrial start all over. The second, the judge says, do you have any opposition to me removing this juror? And counsel says, yes, I do. And then, but if you do remove him, I'm going to essentially renew my mistrial motion. So I think there's essentially 3 different issues before the court. And what was decided in Wilson was, in that case, there was a mistrial as well. There was a mistrial motion that the trial court denied, which this court said it was wrong to deny because the dismissal was under the incorrect standard. Again, 270.15 rather than 35. Excuse me, 35 rather than 15.
So glomming on to Justice Nowak's question, the motion for mistrial. Now, I'm not criticizing defense counsel because you're on your feet and you're trying to do the best you can defending your client. But there was no argument in support of the motion for mistrial that, Judge, I consented to these 5 sworn jurors. Maybe there were 6 by the time this came up. And the mix of those jurors is what I highly value. That is, I balanced my choices or my deselections for jury. That argument wasn't made at all in support of the motion for mistrial. That is, that the defendant somehow had a right to this pool as sworn, correct? That's not been argued.
I don't think the defense counsel specifically put that in front of the court. Defense counsel's most specific objection was citing the Americans with Disabilities Act, the ADA. And so the right.
So with respect to that, was there any opportunity to have any kind of other auxiliary aid, like a cart, or, did they try to do anything else for the juror, or did they just say because the interpreter wasn't available?
Your Honor, what the record shows is that the trial court says that they consulted with OCA and the Commissioner of Jurors, and essentially no one had any ideas. And so this is an issue both in terms of the ADA and also in terms of Judiciary Law 390, which I view as the state codifying auxiliary aids, which the ADA requires. And
that's why, Mr. Friedman, with Justice, that's why I started off with asking you the source of the right. That right under the ADA and under the judiciary law seems to be a right possessed by the deaf juror.
So the deaf juror has the right to the accommodation. The defendant has the right to the jury selected in accordance with the law, and along with that, not deselected by some improper means. Right. And so where the ADA requires the aids to be provided and where 390 requires the same thing, the court cannot remove the juror as, in this case, the standard is unable to serve. The juror was able to serve. I don't believe there was an argument to the contrary. I don't believe that the people are now arguing that the court would have been proper if it had decided under 217.
And just so I can get this out, you're not arguing that the court erred by not granting an adjournment, correct? Because I think the jury was told right up front, this will be a 1-week trial. And I think this is on day 2, on Tuesday. And they were told they'd be done by the end of the week. So you're not arguing that the court made a mistake by not granting an adjournment, are you?
That's correct. That's not the error. The error was, I think there's 3 ways you can conceive of it. Either not granting the initial mistrial and starting all over again, an error to remove the juror, or an error to not grant the mistrial after removing the juror. Just briefly, I'm acutely aware that while I represent Mr. Fleming, there's another important interest at stake in this case, and that, of course, being the interest of the deaf community. So, in addition to asking this court to reverse, I would also ask for some language that that Conway is abrogated by statute when Judiciary Law was 390 was amended, and also that
Conway's in a different context, correct?
Right. So
the full juror was sworn. Here, we probably need to look at incapacity if we're going to go to that.
That's correct. I think this court has several different options about how to go about this. I think in some ways, the 270.15 issue is the most straightforward. I think if this court decides the issue on those grounds, I would just ask for some type of dicta relating to 390, just so that Conway can't be used in the future to keep other deaf jurors from exercising their right to serve on juries.
Thank you, counsel.
Thank you.
Good morning, Christina Harper for the people. I will also concentrate my argument on point 1. First and foremost, I would like to point the court's attention that the argument that the defense is making right now is unpreserved. The counsel below specifically requested a mistrial, which is a remedy pursuant to CPL 270.35, not 270.15.3. And that's—
You point out, as you do in your brief, that this is a question of discretion, correct?
This is correct, Your Honor. Absolutely correct. So even if this court were to review this unpreserved issue, utilizing the standard of abuse of discretion, there's no abuse of discretion. As
The
to that.
mistrial issue is preserved, don't you think?
Under 270-35, but that's not what the defendant is arguing right now. They are
You
arguing
would
that
agree we can't apply that statute in this context, right?
that's not how it was preserved, Your Honor. That's not what was argued
We
below.
could be looking at incapacity.
Yes, Your Honor. Unless the court has any other questions, I will rest on it.
Very good. Thank you, Counsel. Case 343, People versus McGuire.
Good morning, Your Honors. Can you hear me?
Counsel, we can hear you. Can you hear us?
Yes, I can. Thank you, Your Honor.
Please proceed.
Brian Schifrin on behalf of Richard McGuire. The police stopped the vehicle that Mr. McGuire was driving because the mobile data terminal, the MDT in the patrol vehicle, indicated or displayed that Mr. McGuire's license was suspended. Mr. McGuire's counsel filed a suppression motion which challenged the stop because, based on conversations with defendant, there is a question of fact as to the suspension of the license. This assertion that there was a factual issue as to the suspension means that there was a challenge to the reliability of the information displayed by the MDT. There's no other possible meaning suggested. This was not a challenge to the basis of the information, but rather to whether in fact there was a suspension. Because there was a challenge to the fact of the suspension under People versus Lipka, the burden was on the people to establish that in fact, as the MDT displayed, at the time of the stop, Mr. McGuire's license was suspended. The people did not.
Mr. Schifrin, let me ask you this question. Would you say by the mere making of the motion to suppress, irrespective of its content, that is, I contest the admissibility of this tangible evidence inasmuch as it violates the Fourth Amendment in some respect? Get rid of the in some respect. So
no, Your Honor.
To me, you're arguing that merely making the motion and when the court in the exercise of its discretion, without really analyzing whether or not the defendant has stated enough upon information of belief. So that's what I was struggling with, is whether or not just the mere making of the motion puts it at issue.
It does not, Your Honor. I want to be clear what I am and what I'm not arguing. Simply arguing there was not probable cause to stop the vehicle is insufficient. Courts have so held. But the Court of Appeals in a series of cases have held that if you challenge the reliability of the information the police relied on, and again, this is equivalent of a fellow officer rule because the officers in that patrol car had no personal knowledge of the suspension. They were relying on the information conveyed to them by the computer device, by the MDT. When you challenge that information, that switches the burden. And
are you saying that's enough to say upon information of belief without identifying any basis for that belief?
Yeah, actually, it says based on conversations with defendant.
Yeah, but it doesn't say which way the discussion went.
Yeah,
I don't read the papers to even allege that there was any illegality. Just that upon information of belief, there's a question of fact. Well, that's always true when the court grants a hearing. So that's why I say it seems to me you're arguing that the mere making of the motion must amount to be sufficient. And Mendoza, the case I'm sure you're familiar with by Judge Kaye, sets forth what is necessary when you allege suppression of tangible evidence based on upon information of belief. Comparing the allegations there to the allegations here, I would submit, Mr. Schifrin, that your allegations here don't meet what we had in Mendoza.
Respectfully, Mendoza wasn't a question about challenge to reliability. The language in this motion, there is a question based on conversations with defendant. There is a question of fact as to the suspension of the license, has no other possible meaning other than saying we're holding you to your burden, because under Lipka, the burden, if you challenge the liability information, and there's no requirement for on a motion.
But do you even argue there? Sorry, Mr. Schifrin, me again. Do you even argue though? It's one thing to say there's a question of fact. Don't you have to at least in a conclusory fashion allege there was illegality?
The motion argues that pages 16 through 18 of the record argues that the arrest was unlawful, and that's one, and it argues that either the suppression should be granted or a hearing should be issued based on the claim set forth in the motion. And the claim was that there was a factual question as to the suspension. That's not an attack on the basis of knowledge. That's an attack on the information conveyed. The MDT is a computer device. The information is only as good as the information given to it. This court recognized in the 2023 decision, People versus Walker, and I know Presiding Justice Whalen and Justice Nowak were on that panel, that MDTs are not always accurate, and there's a burden. In Walker,
Is that the Walker case, Mr.
yes,
Schiffer?
in Walker,
You understand the Walker case, the defendant attached as an exhibit to his motion papers a specific document indicating that in fact he had insurance. Then he objected to the testimony about the lack of insurance, and then he had his girlfriend testify that it was her car and it was insured. None of that happened here, correct?
absolutely. And I want to address that. I think it's very important. The fact that all that information was put in the motion and after suppression hearing is interesting, but it is not a requirement. There's never been a requirement that to attack reliability that you have to actually bring in evidence. That you have to, it's enough to attack reliability. It's like at a trial. A defendant can testify or bring in evidence, but the burden is on the people. Here, having attacked the allegation that there was a suspension, more was required than simply at the hearing having Officer Sutton testify that he saw the display of suspension. There was no
Counsel, with respect to that testimony, I don't mean to interrupt you, but you're right at the perfect point. When the witness is on the stand during the hearing, Officer Sutton, and he's asked about what he saw on his screen at the time, there could have been an objection hearsay, and then the issue's perhaps preserved. But if there's no objection and it just goes forward, the testimony goes forward, can't the people just rely on the fact, well, there's no objection, and therefore it comes in, now we've met our burden because there was no objection. Whereas had there been an objection, then, maybe we need to call somebody from the DMV. But right now, with no objection, what are the people supposed to do?
What the people are supposed to do, and there's a couple components to your question. The testimony of the officer is admissible because there's a presumption that police could rely on the MDT information, and we don't contest that presumption. But that presumption was met and challenged by the statement there's a factual issue. What the people are supposed to do is, in addition to presenting the testimony of Officer Sutton to establish why he stopped, which I stopped him because the MDT said that, they had to present evidence that in fact there was an active suspension. The DMV driver's abstract.
Mr. Schiffer, me again, sir, just so I have this right. Kind of following up a little bit on Justice Nowak's question, do you agree that defense counsel never made an objection to any of the testimony pertaining to the lack of a license, including the background that I think this officer had 50 encounters with your client, had run his license registration 12 times before, did it again right before he pulled him over. I think 3 minutes was the testimony. And further, not only was there no objection, but there was no post-hearing submission. There was no post-hearing argument. And even on cross-examination at pages 43 to 45, as I see it, defense counsel brought out specifically the information that showed up on the MDT. So it seems like that what information the officer had is not at all in contest. Don't you agree?
There's two components. I agree that your factual recitation of events is absolutely accurate, Your Honor. What I disagree with is the significance of that, because there was no burden on Mr. McGuire or his attorney having contested that. The burden was exclusively on the people to establish there was an active suspension. There might have been a suspension, and DMV records were not updated to the MDT. We don't know that. There was no order of suspension introduced. There was no indication when there was a suspension order, by whom and where. There was, again, no DMV abstract. The burden shifted when that motion was filed. Could defense counsel have done more? Absolutely. Is it required? Absolutely not. And that's the difference. Again, going back to Justice Nowak's question, yeah, it would have been helpful as an appellate counsel to see more, but it's not required because there was no burden on the defendant after he filed that motion. The burden to show that there was an active suspension at the time of the stop was solely on the people. And when the MDT is challenged, they can't rely on that. Again, that's the this a variation of fellow officer rule. There's no dispute that the police officer relied on was on the MDT. Yep, the MDT displayed that. So, computers.
Counsel, let me ask you, is this issue preserved?
It's preserved it's preserved because there was a motion, again, saying there's a question of fact as to the suspension of license, and that is all that is required to put the burden on the people. There's not a requirement to do a post-hearing memo. There's no case law saying if you don't do a post-hearing memo after challenging reliability, that the issue is gone. There's not a requirement to remind the people of their burden. The burden shifted with that motion, and the people failed to sustain its burden.
Mr. Schifrin, aren't there dozens of cases, including one or two I could probably point to you from our court, that indicate if you want to object to the evidence that was received at the suppression hearing, if you want to have it excluded or otherwise considered on appeal, you have to object to the evidence.
Yeah.
And here the evidence came in, the testimony came in clean and unrebutted and unobjected to.
Yeah.
So doesn't that
Again,
meet the burden?
No, that proves one thing. It proves what the MDT said. In Walker, they proved what the MDT displayed. There was an insurance lapse, but they didn't prove that in fact there was an insurance lapse. There's no dispute on my part that I'm not challenging the credibility of Officer Sutton that he looked at an MDT and said, nope, it says suspended. What I'm saying is that is not enough when there's a challenge in a motion to the fact of suspension, and that's what happened over here. Once that occurred, it's not that complicated to get a DMV abstract to show that in fact there was a suspension, which would indicate when and why, which court did the suspension, what the basis was. That wasn't done here. That's a simple thing to have done. It's not the duty of defense counsel to remind the people of their burden. The burden was there, and that evidence that Justice Curran just listed is all evidence of what the MDT showed, which is sufficient initially for the stop. Again, police are permitted to rely on what they see on the MDT or what they're told by other officers. But once that information is challenged, it's not sufficient to sustain the burden to show probable cause. And that's the problem we have here.
Counsel, your time. Oh, go ahead.
Very quickly, just to clarify, asking maybe another way. Let's assume there's an objection next time. Let's assume there's an objection at trial. And they say, all right, we'll call the guy from the DMV. And the guy from the DMV comes in. And he says, oh, you know what? I checked it. I found it. And it turns out that what the officer saw in the car was exactly what he testified to, that the guy's license was suspended. But you know what? We made a mistake on our end, and it actually wasn't. But the officer didn't know that. The officer had a legitimate basis to believe the license was suspended. Is that a valid traffic stop then?
I'm smiling. I apologize. That you crystallized the problem exactly, which is it's valid. And again, initially police are permitted to presume the accuracy and reliability of the information they're getting from other officers or from the MDT. But once it's challenged, and we discover in fact that the suspension had been lifted, or there was no suspension, or something else was wrong, then the answer is no. Then upon that, the burden to show that it was a valid suspension is not met, because the reliability of the information on the MDT was not established. It was established that the MDT showed that, but the MDT was wrong. Like I'm doing this remotely. My computer gives me information that's wrong all the time. Okay, the databases are not necessarily accurate. So once you challenge the allegation that the information that the officer was basing the stop on, once that's challenged, the people have the burden of showing in fact that information was correct. Here they fail to meet that burden. Therefore, even though initially their action was proper, you see a suspension on your car computer, you stop the guy, but you discover, oops, in fact, that suspension was lifted a month ago because he paid the fine or whatever. That is not a valid stop, because the reliability of the information wasn't there. If we had a different rule, there would be, in fact, discouraging of police agencies and DMV to update information and have accurate information. We want to ensure there's accurate information. The best way to do that is when you challenge inaccurate information and they can't establish it, then the presumption of legality fails, and the stop is unlawful. And in this case, the suppression should have been granted. Thank you, Your Honor.
Counsel, thank you for your argument.
Good morning, Your Honors. Ryan Ash for the people. I'm going to focus on point one as well to respond to counsel's arguments. I think your questions are rightfully going at the heart of whether or not this issue is preserved, because in my mind, it's not preserved. And the important reason why I have to rely on the fact that it's not preserved is there's nothing in the record to go to the merits of this argument. And that's, to me, that's kind of the underlying rationale behind the preservation doctrine, is that this court would be making this determination on the merits of defendant's argument without having a record to base that determination on. And I think that going back to Justice Curran's kind of, I don't want to dismissively use the word rhetorical, but your question about, is it the same as just being granted the hearing, right? Like, does the court's grant of a hearing essentially say, okay, therefore the people have to prove every single burden that they have under the law? I don't think that the answer to that question is yes. I think the answer is they have to prove the burdens that the defendant is asking them to prove. And
didn't the burden shift when the defense made the motion?
No, Your Honor, I don't believe so, because my interpretation of the record is always that the trial counsel's argument was that essentially the credibility of the police, and counsel here did say he's not challenging the officer's credibility, but I think the trial counsel actually was, that the issue was the timing of the stop.
But was he questioning the credibility of the officer or the reliability of the information that the officer used? And that's why the burden shifts?
No, I disagree. I think he was actually challenging the credibility of the officer, because there's a chance that in fact, we don't actually know. Was it counsel's argument that the cop lied about what he saw on the screen? It's more about, yes.
Counsel, is it your position that the motion papers had to state, we are challenging the reliability of the DMV data, in order for the people to be aware or have noticed that they needed to present that evidence, to satisfy their burden at the suppression hearing?
In the general sense, yes, but not. I don't want to be that specific, because the defendant has multiple opportunities to make that.
He could have done that, made that request, or presented that claim at the hearing itself.
He could have made it at the hearing,
but that wasn't done at the hearing. The only issue we have here is whether or not that statement upon information and belief was sufficient to attack the presumption that's in place.
Right, Your Honor. And I think that appellate counsel is right in his argument today that the defendant doesn't have the burden to make post-argument submissions, doesn't have a burden to do these things. But my argument is simply that, yeah, you don't have the burden to do so, but the fact that you didn't do so is an indication that that's not really what the motion was about below. The motion below was about the timing of the stop. When did the police officer access the database to determine that this license was suspended? Because, and this is a little bit of reading between the lines, which is what we kind of have to do here, but the trial counsel mentioned these records, the DMV records, a couple times, not in the actual testimony or in the form of an objection, but like as they were scheduling things, and said, yeah, I'm trying to look at these readouts. I'm trying to look at the database information to look at the timing of when this data was accessed. And that, to me,
the audit trails.
Yes, it shows that he's worried about this alternate possible but hypothetical fact pattern where the police officer sees the defendant, determines to make a stop, and says, I'm going to pull this guy over, and then does so, and then puts his information through the database and comes up with a excuse or like a wraparound reason for doing so. And I think that's really the argument.
Defense counsel's looking for it, but at the hearing, the officer clearly testified that, in fact, it was funny. He came up with this. He was asked, maybe by defense counsel, how long was it between when you looked at the MDT and saw that it was he was an unlicensed operator, and when you activated the emergency lights? He said 3 minutes.
Right. And I watched the body camera footage this morning, and it turns on less than 3 minutes from when the stop occurred, and there was already information up. I couldn't read the information. I looked at the computer pretty closely, but I couldn't tell if it was defendant's information. And that's the whole reason we had this testimony. And I think that, once again, the people could have called the DMV witness, offered some sort of actual readout of the database and the basis for supporting that his license was suspended if they were asked to.
And that's
But
sort of where I'm
wasn't there a judicial subpoena requesting that information? Didn't defense counsel ask the court for a judicial subpoena to get that information and didn't get a response before the date of the hearing?
Yes, Judge, but I would say that's evidence that, and also that's the defendant requesting the subpoena. It's not, the defendant wasn't saying the people didn't introduce these records that were subpoenaed and therefore they didn't meet their burden. I think this is sort of a, like, there are two issues that sound quite similar to each other. And on appeal, we're arguing one that wasn't actually argued below. And they do sound quite similar, but they're completely different issues. And I don't think in your motion papers, essentially arguing that a hearing should be granted, automatically entitles you to
Let me
the.
follow up on that, Counselor, because I'm looking back at the motion papers filed by the defendant and in response. And at pages 36 to 37 of the record, the district attorney's office very clearly argued that under CPL section 71063B, where when a motion is made upon information of belief, if there has to be the basis of the belief is supposed to be shared. And the leading case that your papers cite there is Mendoza. Mendoza, the opinion by Judge K, talks about this is enough for upon information of belief and this is not. So you argued in your papers below, Judge, there's no reason to give a hearing even, and that they didn't meet the burden upon information of belief. The court didn't even really address that, just I'm going to give you a hearing. Where I'm going with this question is, if we say that this is enough in the motion papers, in this case, despite the absence of any objection to the evidence received at the suppression hearing, and despite any evidence to the contrary, that in fact the defendant was licensed to operate a motor vehicle, aren't we then inviting the DA's office and the courts to more stringently apply this requirement that there be more than just upon information of belief? We could then end up having at this end multiple appeals where the issue is the court should have granted a hearing, and because it didn't, we're going to remit. But here the court is allowed to exercise its discretion under Mendoza and simply say, I'm going to give you a hearing. So we'd be discouraging, in my view, hearings. Do you agree?
You'd be discouraging hearings. I think that, right. I want hearings. I want the issues. If the defendant has an issue about he thinks he was unlawfully arrested, he was pulled over, and that suppression of the evidence is required, I want all of his basis to be challenged at the hearing. And I'm arguing that his basis was drawn out at the hearing. There was testimony put in to essentially establish the timing of the stop. And if they wanted an additional basis, the one that they're arguing on appeal, we should have had some indication before now on appeal that that was the basis, so that we could have put in evidence to address it. Thank you.
Thank you, Counsel. Case 344, Royal versus McCarthy, Superintendent of Elmira Correctional. Counsel, it appears you're alone on this one.
Yes.
Proceed.
Morning, Your Honors. If there are no questions, I do intend to rely on my briefs in this matter, but I just want to, before I do that, I want to bring one thing to the court's attention, which the court may already be aware. The double jeopardy issue that is raised in this habeas appeal is also raised in a direct appeal that was argued in the court's February term. I believe several members of this panel were on that panel, although it's not the identical panel.
Case 214.
Yes. And so that the issue is raised there. It's currently pending. And that would most likely be dispositive of what's done here. Unless the court has any questions, I will rest on my briefs here.
No questions. Thank you, Counsel.
Thank you.
Case 345 and 345.1, Lebetru versus Senate. Counsel, can you hear us?
I can hear you, but I can't see you. Hold on. Can you see me now?
We can see you
Good
very
morning.
well, and we can hear you very well. Counsel
Thank
Rook?
you. Good morning,
I
Your
can hear you,
Honors.
Judge. Very good. Okay, Counsel, let's proceed.
My name is Patricia Grant, and I represent the appellant, Ashley Sennett, in this case. I'm certain that the court has carefully reviewed all the briefs, so I will address only the highlights of our arguments this morning. The parties entered into a parenting agreement in Kansas in 2022. The respondent father is a military officer who was stationed in Kansas at the time that the parenting agreement was entered into. The parties took special care to address the issue of respondents' potential permanent changes of station or deployments. Thus, they provided language at paragraph C of their agreement that reads as follows.
We have that, and we can read that language, and it's very well brought out in the briefs. You can proceed and assume we know it.
Okay. Your Honor, I just don't think there's any reasonable analysis under which a court can logically conclude that based upon the language in paragraph C, it's the appellant mother who should be the party to travel to respondent's residence to be with her children or relinquish her career ambitions. I think the language is actually clear. And I think the only
Counselor, the court and your opponent's position is that language doesn't apply here because there wasn't a permanent change of station.
There wasn't a permanent.
At the time that the agreement was entered into, he was on his way to Fort Drum. Everyone knew that this would apply if there was a future change.
There wasn't a future permanent change of station, but he was deployed for 9 months, I believe.
Well, no, listen, there's a big difference between being deployed and having a permanent change of station.
Well, he was deployed for a long period of time, and the children were in school. They were moved to Maine at the time that he was deployed. And as the court knows from the briefs, the family court directed that as soon as he returned from his deployment, which was first 6 weeks and then 9 months, that the mother had to return to Fort Drum with the children to be with him. So I think the issue is really who bears the geographic burden. I don't think it's the mother. I don't think that there can be any interpretation under which it can be said that the mother should bear the burden of the geographic relocation.
Very good. We hear that argument and we'll consider it. Anything further?
I just have a question about the mother's petition and whether or not the best interest analysis was engaged in.
Well, that's the other issue. The mother, once the father made his application, Your Honor, the mother, out of an abundance of caution, made an application to relocate. The children were in school in Maine. They had their extended family in Maine. They had their friends in Maine. They had a place to live in Maine. They had activities in Maine. So I think it was clearly in the best interest of the children to be able to remain in Maine rather than returning to Fort Drum. I mean, the father could be deployed once again, and it seems to me that the father's position is if he's deployed again, then the children should still be in Fort Drum, and his girlfriend will take care of them. I don't think.
Counselor, on the cross petition, isn't it procedurally the request to relocate and the request to modify the parenting agreement were one and the same? That was a singular request.
Yes.
Okay.
So I think it would have been in the best interest of the children for them to have been allowed to remain in Maine, Your Honor. The father, nowhere in his brief does he indicate what he believes this provision at paragraph C means. What does it mean that he will bear the burden of geographic separation? And is deployment really any different than a permanent change of station?
Thank you, counsel. Anything further?
No, that's all.
Thank you.
Okay.
Good morning, Rebecca Cons on behalf of the respondent father. As an initial matter, our client reached out to us and these parties have been back in court. They actually were scheduled to have an appearance on Thursday, but the council has sent a letter to court saying that they've reached a settlement agreement. So based on that, the court canceled the appearance that was set for tomorrow. And they have reached a stipulation, so the court is just waiting to put the stipulation on the record. The agreement maintains that 50-50 custody arrangement. It reflects how the schedule's been functioning in practice, which is that week on, week off visitation with dinner during that time to the parent that doesn't have the children at that given time. And it added some clarity around the logistics and vacation time based on how they've been living with this agreement. So once that is put down on paper, we will send a copy to the court. I just wanted the court to be aware that there has been this settlement agreement.
Please expedite that order when it
Yep,
to us.
absolutely.
Thank you. Proceed.
And I would just like to say that the court did correctly interpret this parenting agreement. This PCS clause was a permanent change of station, and a PCS is a very distinct term for military personnel. It's very distinct from deployment. Deployment means that your duty station remains the same. So you go off, you do whatever your deployment is for, and then you come back and your duty station stays in that area. A PCS is a very distinct move for a military member. So this agreement, which they had counsel, they had court, everybody was in agreement. This was an agreement between the two parties who were represented, how this was going to work. And there was no PCS during this time. Just because he was deployed for 9 months, that's not a permanent change of station. That does not impact, that does not trigger that clause. And because of that, her moving to Maine unilaterally without giving any notice to the father, yes, they had an agreement that during the summer months, she was allowed to take the children to Maine for a month. But under that agreement, they were supposed to come back. So she jumped right over that agreement that they had all agreed to and made this unilateral decision to move these children. So all those claims about the stability and her job, that all occurred after she made the decision to violate the agreement that they had. So this was something, so all those claims about best interest of the children were all done after she had already violated that. They were stable. They were actually doing really well in their school. They were reading above school level for where they were. So all that stuff happened after she made that choice to violate the order. There was nothing in her defense that said that she couldn't get a similar job in Jefferson County. The job occurred after the move. She didn't move out there for the job. She got that job after the move. So there's scheduling and timing for all of this. It's a 9.5-hour drive between the parents. The court went through all the tropia determinations and decided that keeping these children together, this agreement had looked at that once the second child got old enough, they were going to have a 50-50, a 50-50 split. That's what was maintained. And that's what's still being maintained under this new agreement. That's what's best for these children. It's how they're going to flourish, having two parents. And the father has right along been discussing with the mother, if he does have a PCS, what that PCS is going to look like. And he's been more than willing to have discussions with her about moving to some place that's going to be close to where she wants to be. He hasn't unilaterally made these decisions like she did.
Counsel, my question is on the cross motion. Is the settlement that they reached, does it encompass that cross motion?
Absolutely. They have this, they've reached this agreement that this is what's going to happen. So they've failed to prove that the relocation was in the best interest. The father's new position at Fort Drum is a 9-to-5 job. He can be guaranteed to be in Fort Drum until 2030, which both kids should be, through school at that point.
So he is trying to give these children the most stability, and the court reached the right conclusion.
Thank you, counsel. Counsel Rook?
Good morning. May it please the court. Bradley Rook on behalf of the children, Emmanuel and Paulina. Just briefly to piggyback on some of the issues that the appellant raised. Notably, my clients want to move to Maine and reside in Maine. In the enforcement petition, I could not square the appellant's argument with the law. I think when you look at the matter of Studentroth and Brzezinski, you can't have a self-executing order. And I don't think that provision can be read to give the mother the unilateral right to move with the children. Conversely, I do think that on the modification petition, the court overlooked the weight of the tropia factors, which I believe weighed heavily in my client's best interest to remain in Maine with a stable environment, their extended family, and notably the mother had significant economic benefits and enhancements there. Largely, I'll rest on my briefs. If the court has any questions, I would welcome them.
Thank you, counsel. Case 346 in the matter of Carl Martin versus Martin. Also,
Good morning, Your Honors.
we're alone today, right?
That's okay. I think I can handle it.
Very good.
Vera Vinkova, attorney for the 4 children subject to this matter. I would like to start with an update for the court pursuant to the matter of Michael B.
Please.
There have not been any subsequent filings. However, because the school district and keeping the children together were the crucial questions in the proceedings below, I can report that all 4 children are in the Letchworth School District, so they're in a school together. They are residing with their father. Unfortunately, they're only seeing their mother every other weekend. I think there were logistical issues that had been discussed during the trial, and they have resulted in this schedule, probably because the same logistical issues remain today. My clients are seeing their paternal aunt even less, but other than those complaints, they're doing well in school. Their attendance is good. Their grades are fine, and I met with them last week, and they were A-okay. So unless the court has any questions, I will rest on my brief.
No questions, counsel. Thank you.
Thank you.
Case 349, Vince's Pizza Plus Inc. versus Fredericks.
Good morning, Your Honors. May it please the court. Brittany Lee Pemberthy appearing on behalf of appellant plaintiff Vince's Pizza Plus. As background, originally, I know Your Honors, I'm not sure each of you previously heard this case similarly, but as background, originally respondent was an employee of appellant, had filed an action for lost wages against a respondent employer in that action. In that original action, appellant asserted certain counterclaims. Respondent amended his complaint, and the lower court allowed appellant in this case to amend their answer. An amended answer was filed and proceeded until Your Honors decided in an action or in a decision of June 2024 to strike the amended answer. Thereafter, appellant timely pursuant to CPLR 205A commenced the instant action, raising those 2 claims that were previously asserted as counterclaims. One for conversion for revenues not deposited in appellant's accounts, and secondly, for breach of a fiduciary duty when the respondent is accused of failing to operate the business within prescribed business hours.
Has the defendant already collected the judgment in the action where he was the plaintiff against your client?
Collection, no. Judgment has been filed, but no collection.
Okay. But is there anything about the claims that you're making that affect the ability to do that?
No, not at all.
So it doesn't, you would argue it doesn't impair the defendant's ability to pursue his judgment under the prior action?
No, not at all. There's no impact on the judgment. The judgment has been had, it's been entered, and certainly he's free to collect in any means he sees possible. But there's nothing that precludes it in this instant action.
So your claims are separate insofar as you say, well, maybe entitled to the wages for the hours you worked. The conversion is what if you took money from the business, you got to pay that back, but that's separate. And if you weren't open when you said you were open, it's not that you're seeking to deprive him of hours worked. It's more of a lost business revenue because it wasn't open. We could have, made this much money during these periods of time when you closed improperly.
Right, they're completely distinct claims. While the parties themselves are identical, the claims are distinct. Let me make that clear. The trial court in this case granted respondents' motion to dismiss, raising the issues of collateral estoppel and res judicata, which obviously appellant is here disputing. Beginning first on the issue of res judicata, appellant submits that it is inapplicable in the present action, because these causes of action were not the same, were not previously determined. This was not a lost wage claim being re-circumvented in any particular fashion. They've not been previously adjudicated. Appellant, in citing the Court of Appeals, People v. Russell, argues that the analysis should be whether or not appellant has had a fair opportunity to have these particular claims, these two distinct claims, adjudicated, and whether the issues are identical. Obviously, we submit they are not. We've never had these claims adjudicated before. We tried to have them adjudicated, but unfortunately, obviously, the striking of the amended answer precluded that ability. And again, we submit these claims are clearly distinct from a claim for lost wages.
In terms of can I ask you a question about the timing? So while this case was on appeal, the judge below had, I think a prior judge in the case, had granted your ability to serve the counterclaims again as part of an amended answer.
Correct.
And then you did that. And so then you're proceeding and you have claims pending all the way up through, and again, appeals pending, all of that, all the way up until you got our decision at the end of July of 24.
June of 24, Your Honor, but yes.
June of 24. Thank you. And so you didn't file a new action because you had that action pending that whole time.
I couldn't file a new action by virtue of the fact that my claims were existing, were timely filed, obviously by the decision of the lower court, which I understand that Your Honor's overturned, but I couldn't file any other action because it would have been duplicative. I already had pending counterclaims, which the lower court was allowing me to proceed upon, again, distinct from the claim of lost wages. So I couldn't necessarily file another action. I couldn't assume what Your Honors were going to decide. I couldn't do anything. There were viable claims existing until Your Honor's decision of June of 24.
And by the time we decided that the statute had run.
The 3-year statute had run, yes, but that's when CPLR 205 comes into action because there was no decision that was necessarily determined relative to the counterclaims. There was no allegation of lack of personal service or personal jurisdiction, I apologize, Your Honor, or anything of that sort. Everything was proper. It was by virtue of the striking of the amended answer that invokes my ability to recommence claims that were otherwise timely filed. I must do that within 6 months, of course, operating under the statute. But that was done. This action was filed within 3 months. So they were timely originally filed by commencement of the counterclaims, assertion of the counterclaims, I should say, and then timely done by commencement of that subsequent action within the 3 months of this court's previous decision.
So was there anything statutorily or rule-wise that precluded you during the time frame that Justice Nowak is just referring to for filing a new summons and complaint based upon those claims, which you had an independent right to do, even though they were arguably already contained in the counterclaims that were, you believed, proper and before the court? Is there any way belts and suspenders file the summons complaint and then just say, that's fine, I'm just protecting my statute of limitation in case there's some procedural problem down the road?
No, in fact, the respondent in that action or the defendant in that action could move to dismiss it because, again, it's duplicative in nature. I can't preemptively file a subsequent action on a chance that there's something wrong with my initial action. I, of course, have recourse in an original filing.
So your answer to my question is that you couldn't do that because there's a possibility that the party could move to dismiss that action based upon the pending action.
It would be improper for me to have filed action.
But you've been saying that a couple of times now, and I'm saying, why is it improper? Is there a rule or regulation that says that that's improper that you've cited to?
You can't file two actions of the same claims at the same time. And by virtue of the interposition of the counterclaims, I had an action already pending. There's a
3211A somewhere, there are two actions pending. I'm not sure I got that right, but that's in my memory somewhere.
Yes. He could move to dismiss, or defendant could move to dismiss based upon that because I already had pending counterclaims. So,
and had that happened, I'm just trying to figure out how this may play out. Had that happened, then I think the defendant in that claim might be precluded from making an argument later on some, reason why you shouldn't be able to preserve that suit because they've waived any objection to the statute of limitations.
I would agree with Your Honor. I still think it would be improper for plaintiff's counsel to assert another action when there's already an action pending for those claims. So I think it would be
beaten that enough.
Yeah.
Thank you.
Improper for me to have done that.
Right.
And I did not do that. I had viable causes of action by virtue of the lower court's decision to allow my amended answer to proceed. I would also note, in the original answer, those counterclaims also existed. So it was never as if this was a late decision after obviously, judgment did not go as I saw it would go. But certainly it's always existed. And it was just by Your Honor's decision that necessitated me to file a subsequent action so that I could preserve the right to bring those claims.
You see, that's the way I understand the first action. It was a sort of sorting itself out. It was a complaint. It was an answer. You didn't default on the initial complaint. And then there was an amended complaint and then the amended answer. And we're sort of started working through this because the nature of the claims that are presented in this particular action in front of us right now did not need to be brought as counterclaims.
They did not. There was
Which
a
is
requirement.
part of your reason and your basis for saying that they can proceed at this point.
Right. They were completely distinct of a lost wage claim. However, if the parties are similar, right, obviously, and there were claims being asserted in one direction, it was completely within respondent or defendant, in this appellant defendant's right in that underlying case to assert counterclaims, which he did. And those counterclaims were completely distinct and could have been even commenced in a separate action. He decided in that action to assert counterclaims, again, distinct from lost wages. That was his right.
Right. Are you familiar with the case of Berry versus, I think it's Batash? It's in Second Department. It came out 2 weeks ago.
I'm not, Your Honor. Unfortunately, I haven't been following the Second Department that closely. Sorry.
Just on the issue of whether something that was not asserted as a counterclaim could have been then attempted to be asserted later. Basically, it addresses the permissive counterclaim rule, but that's all right.
I do think obviously this court's decision in Miller versus Lancera should allow for obviously these claims that are being brought presently to continue. I think in that case, a party was not permitted to assert certain claims and then later subsequently asserted those claims. I think obviously the Wells Fargo Bank versus I'm not going to pronounce it correctly, I apologize. Paduswick is also a Fourth Department case in which this court previously decided res judicata in that case does not apply if a party fails to raise a counterclaim, which is kind of what happened here. By virtue of Your Honor's decision to strike the amended answer, that defendant in that case was not allowed to pursue those counterclaims. So that same logic in that case should be applied here. Just because a counterclaim did not exist doesn't preclude a person from asserting it. And that I submit, unless Your Honors have any additional questions, should allow this case to proceed. I am asking this court to obviously overturn the decision of the lower court.
Thank you, counsel.
Thank you.
May it please the court, Brendan Burke on behalf of the respondent, Dion de Federicis. With all due respect to my opponent, I think she has it upside down and backwards with respect to res judicata. Is the res judicata case
issue, Mr. Burke, on appeal?
Excuse me, Your Honor.
Is that the critical issue as far as
Absolutely, absolutely. You can get to statute of limitations, but I don't think you need to get to it. Res judicata here, this is an absolute textbook case of res judicata. My opponent seems to be saying that she can default in action number one, have pleadings dismissed in action number one, and then turn around and start action number two, and then assert those same pleadings. Those prior pleadings were dismissed on the merits.
Let me just suppose for a second, assuming arguendo, that we respectfully disagree with you on res judicata, does that decide the appeal?
Res judicata decides the appeal.
Okay, either way.
Res judicata or statute of limitations, either one. You don't need both.
Okay.
One or the other, we win. If we win on res judicata, we don't need to go to statute of limitations. If for some reason you decide this is not a res judicata case, and I don't see it that way, but if for some reason you get to the point where you say it's not a res judicata case, we still win on statute of limitations.
And why is that?
because all her claims are 3 years or less, 3-year claims, and they weren't, and the statute began to run in the end of May 2021, and she didn't assert the claims until September of 2024. She does not get the benefit of CPLR 205A because by the express, very clear language of the statute, CPLR 205A, it does not apply in a situation where there was a valid final judgment which terminated action number 1, the prior action. And that's what we have here. A default judgment, even though it's a default, is a valid final judgment on the merits. We have many cases in our brief.
Is that a judgment on the merits of your client's claims that were brought as primary claims in that action? Or is it a final judgment also with respect to counterclaims?
It's a final judgment with respect to all claims that were operative in that action. At that time, her answer to the our amended complaint and counterclaims were in the case. Judge Sywak granted that order below, letting that in.
Not at the time of the judgment.
Excuse me, Anna?
At the time of the judgment, there were no counterclaims. We took them out about 2 months before.
That's true. There were
no counterclaims in effect at the time of the judgment. The judgment makes no reference to any counterclaims. Judgment is only for your client's claims. And received a judgment with respect to all of those claims. But there's no judgment respect to so why would we would consider that to be on the merits of the counterclaims when there's no reference to it at all?
Well, let me give you 2 cases. Zayats versus Collins, which is this court's case from 2006, I believe.
Yep.
The prior action is a divorce action. The defendant wife defaulted in that action. She didn't even allege any counterclaims therein.
But then when she later brought her claims, they would have impaired the judgment in Zayats. I have Zayats right in front of me. They would have impaired the judgment because the judgment said, basically, husband, you get to keep your bank account. And her claim was, well, he took money from me, he put it in that bank account.
Yeah.
And so therefore he doesn't get to keep his bank account. Well, he had a judgment that he could, through equitable distribution, keep the bank account. So the issue is, that's why I started that with opposing counsel is, do the claims that she's making in the counterclaims impair your judgment, your client's judgment? It seems that your client could collect the judgment whenever your client collects the judgment.
And then it would be offset if she gets a judgment.
Look, if he collects the judgment and then takes the money, spends all the money, and then they get their judgment against him, they're gonna have to wait until he has enough money to pay the judgment.
Well, not necessarily. I mean,
Why?
because it's an offset. If they get a judgment against us, they can pursue us to collect the judgment.
Sure, but he still gets his judgment first. He already
Just because it gets his first doesn't mean he gets the entire judgment if they get to offset it. These claims are absolutely related. They all arise out of the same transactions or series of transactions. They all arise out of the employment of my client, DeFedericis, by Vince's Pizza, the
Let's just
appellant.
focus on that point for my benefit right now. Maybe I'm missing something. But your argument therefore is that even if there had been no counterclaims, these claims, such as they are by the employer, would be gone.
That's the holding of Zayats. That's also the holding of a second department case, which we found. I'm sorry, it's not in our brief. I'll give you the site. Santiago versus Leilani, Lalani, 256 82nd 397, second department, 1998. The facts in that case are virtually identical to our case.
Okay, but so your point is the same, even if there had been no existing counterclaims, because they were something that could have been raised. Because
Absolutely.
it kind of applies to that.
And that's the law. I mean,
And
that's not just me.
So then, just conceptually, for my benefit, if we respectfully disagree with you on race judicata, doesn't that answer the 205A question? Because that judgment won't be final vis-a-vis the counterclaims because we're finding that race judicata. So what I'm driving at is, you say there's 2 issues. I view them as conceptually related, such that if we decide race judicata contrary to your position, it answers the 205A position. That's what's on my mind. What do you think?
I think 205A is clear. If the prior action was terminated by a valid final judgment,
That applies to the claims that are trying to be precluded.
Well, you know, she's in a funny position with respect to 205A because she was not the plaintiff in the prior action that was terminated. She was the defendant. So arguably 205A doesn't even apply to her situation. Because she wasn't a plaintiff bringing the claim. But I mean, 205A is.
Your argument doesn't require that she filed any claims, is my point. Your argument is, you know, because the final judgment forecloses her counterclaims, even if she never raised them, they're gone, and therefore 205 applies because it's a final judgment vis-a-vis whatever claim she may have been able to raise, right?
Yes, and my claim is totally, my position is totally supported by Zayats. It's totally supported by Santiago versus Leilani and a number of other cases. But those are the two main cases that I see with the closest fact pattern.
Counsel, doesn't 205B refer to counterclaims?
I'm sorry, Your Honor, I don't have that in front of me.
Okay.
Counsel, I have Santiago.
I think we looked at it in our brief and that does not apply, but I'd have to revisit that. It's not in our brief. I apologize if it's not there.
Okay.
Santiago v. Leilani, the court held that a party is not free to remain silent in the action in which he's the defendant, then bring a second action, seeking relief inconsistent with the judgment is the language that they use in Santiago. How is the relief that they're seeking here inconsistent with your client's relief that I get my wages for the time that I worked?
Well, it's the exact same situation as in Leilani. There was a doctor who brought the case in action number one against some of the people on his staff who were mismanaging his medical practice, and that they defaulted, just like appellant here defaulted in action number one, and then they tried to turn around and bring action number two, suing the doctor for claims they allegedly had against the doctor. So it would impair the judgment because it's an offset. We don't get the full benefit of our judgment that we earned fair and square, and she gets the benefit of a second bite of the apple because she defaulted. It's turned upside down. She should not be rewarded for a default. She should be punished for a default.
Your argument would be if there's ever any time where there could be a financial offset of one judgment for another, so that if, as your client was leaving work one day at the pizza place, he backed his car up, he hit the side of the building, damaged the building. It cost a few $1,000s. They can't seek that either because it would be an offset.
That's a different situation.
But I know, but we have to define it. We have to define when it is, when it's not. You said it's just because it's an offset. Well,
it's because
too broad.
It arises out of the same transactions or series of transactions, which is the clear law in New York State.
The fact that he was an employee.
Excuse me, Your Honor?
Which you define as just simply the fact that he was an employee. That's the series of transactions, his employment.
Well, yeah, he's working at the pizza shop and he's making a wage claim, and they're turning around and saying, well, he didn't manage the place properly, or there's this alleged conversion, which we deny. And
but they're
totally interrelated transactions.
They're not claiming he didn't earn his wages. They're claiming he damaged the company separately from that, separately from the hours worked.
Why? I don't understand why that's not the same transactions or series of transactions.
We could certainly take a look at that, counsel. Anything further?
Nothing. Well, statute of limitations, we talked about that. 205A does not apply. I think everything is a 3-year statute. We've got it briefed, so you can look at that, but no, that's all I have. Thank you.
Thank you, counsel. Case 351, Handy versus Teachers Insurance and Annuity Association. Counsel, proceed.
May it please the court. In February 2024, TIAA counsel told the motion court plaintiff had produced the entire TIAA file, but that was false. It is of supreme importance that the first time plaintiff learned she had not received TIAA's entire file was when she opened TIAA's brief in February 2025. Contrast the exchanges at oral argument on February 22, 2024. When the court asked, "You have submitted everything?" Question mark. Mr. Linares answered, "Correct." When the court asked, "Everything?" Mr. Linares said, "Yes." When the court said, "But it would be helpful for me to know, and for him, my prior counsel, to know that you have nothing," that's correct. Mr. Linares added, "There's nothing more to give." The court ended the subject by telling plaintiff's former counsel, "You have everything." Now, early in the transcript, Mr. McGorry stated, "Mr. Linares, on behalf of TIA-CREF, has provided them with reams of discovery, everything they have in their file, in their computer systems, audio files, everything they have. So there's nothing more that could possibly ask for. They could possibly ask for." And Mr. Linares responded, "I would just add there's no extra discovery that would be available from the position of TIAA." In the March 6th, 2024 order, Her Honor Justice Sywick wrote, "And this court, having taken judicial notice based upon the representation of Joseph L. Linares, ESQ, attorney for defendant TIAA, that any and all documents, communications, and/or information in the possession of TIAA related to decedent Cynthia Galvin and/or the TIAA annuity retirement plan of Cynthia Galvin has been provided to the attorneys for plaintiff Colleen Pandy." Now, I say this just to note that there is a question whether there is an issue here under the rules of professional conduct, Rule 1200.3.3. What was stated was false. The decision was based on a falsehood. My client had discovery demands that were pending at the time of the summary judgment motion. And my opponents say they're untimely, but let's look at this. There were 6 weeks.
Counsel, let me just ask a question. The discovery demands that were pending, did they address the disclosure of the document or documents that you claim were not turned over?
Yes. The notice produced said they want the section of the online portal which details the decedent's beneficiary designations. So the request was made on February 14th of 2024. I hope that addresses your honest concern.
It does. Thank you.
And so we're told these, oh my God, these notices to produce were so untimely. 6 weeks, which in our business is a minute. 6 weeks went by between Mr. McGorry's discovery demands and my predecessor, Lippis Mathias's discovery demands. And this case, because of the intervenors, because of the stay, because of an injunction, issue was not even joined until the second half of August 2023. So having discovery demands from my side in February 2024 is nothing shocking. Let's talk about the metadata. TIAA, in its answer, admits paragraph 19 of the complaint, which alleges that TIAA's, quote, portal contained the beneficiary designations in a conspicuous place visible to the individual using the portal. TIAA's brief admits on page 23 that the decedent could have designated beneficiaries using her, quote, online account portal, close quote. Plaintiff's February 16 affidavit testifies that the decedent used the online portal to view the performance of her TIAA retirement accounts and to view her beneficiaries. The TIAA brief admits on page 31 that, quote, the only discovery which was not voluntarily provided that Pandy seems to identify is metadata associated with decedent's online account portal. Plaintiff's notice to produce requested the section on the online portal which details the decedent's beneficiary designations. Meanwhile, TIAA submission closest to being admissible on the ultimate question is its attorney's affirmation, pages 363 and 364 in the record on appeal, stating, quote, the production did not include a change of beneficiary form as no such form was completed or submitted by the decedent to TIAA, close quote. There's no showing that Mr. Linares was competent to give this testimony or even read TIAA's entire production. Now, I've known some of the justices on this panel for decades. Things have evolved. The appellate division decisions do not let lawyers testify for their clients, and we don't have a client testimony here. Their case rises or falls on a call they say is fatal in my case, which helps my case. That was the call between the decedent, Cynthia Galvin, and two representatives of TIAA, Richard Brewer and Jonathan Fulton. That call helps my case, and it comes very importantly, almost 3 full years before Miss Galvin died. During the call, Mr. Fulton says, we probably have this information in our archives, but currently there is no definitive beneficiaries set forth for you, so you may want to get online to change that or update that with some actual individuals. Richard Brewer says to the decedent, but like Jonathan said, definitely want to get those beneficiaries. I'm surprised I didn't notice that beforehand, close quote. That indicated that the decedent's regular representative, Mr. Brewer, had not discussed beneficiaries with the decedent until 2018, only planting the seed at that moment, 3 years before her death. Mr. Fulton admitted, quote, we probably have that information somewhere in the cave. That's the exact word, cave, somewhere. But in case you pass away, that is probably going to elongate the process if we have to go shuffling around in the cave to find that information. So that might not be a bad idea to just update your beneficiaries accordingly. During the December 18, 2018 call, which is the only evidence proffered by defendants and interveners that no change in beneficiary has been made, the two representatives of TIAA obviously proceeded with a misunderstanding of the status of Cynthia Galvin's beneficiaries for annuity. When the TIAA agent stated that, quote, currently there's no definitive beneficiary set up for you, close quote, he misled Cynthia Galvin because, as TIAA discovered years later, it still had her original 1981 application from when the decedent started her annuity. TIAA's agent, Mr. Fulton, assuming there was no existing designation, stated that designation should be, quote, set up with actual individuals, close quote. Furthermore, TIAA's Richard Brewer stated he will, open quote, keep warning you about that as we continue, close quote, referring to his fiduciary duty to assist Cynthia Galvin in ensuring she has designated current and accurate beneficiaries. At no point in the 2018 conversation was the decedent informed that intervenors were her contingent beneficiaries listed on her annuity contracts, and a plain reading of the transcript of the call establishes that the decedent was led to believe that there were no beneficiaries listed. Contrary to intervenors' assertions, this telephone call does not in any way indicate the decedent knew that her beneficiaries had not been, quote, updated since the initial designation 1981, because there's no reference to the original designation. As far as she was aware, from the content of that conference call, there were no beneficiaries whatsoever who had been designated. Contrary to the allegation of the respondents, the decedent was uninformed regarding the existence of any beneficiary designation.
You know, let me ask you a question. There comes a point in time with this conversation with the decedent regarding the need to maybe change your beneficiary. And she makes a comment, you'll have the record much better than I have, that it's in her tickler to do that. But she hasn't gotten around to doing that. but it hasn't tickled her yet, or something along those lines, right? When did that take place, that conversation?
3 years before she died.
Okay.
We want to,
And so that, is that some indication that she knew that she had designated beneficiaries of the account? And that she was thinking about maybe changing that?
no, I think that was a realization by her that she hadn't done any designation whatsoever, and it was time. And what's important about that conversation, which is in the record, she's saying, I am going to do something about designation. There was an intention to change designation. We need the 3 years of metadata. I'm going to say something. It's either there or it isn't. If it's not there, I lose. I get it. But if it's there, if she went on the portal, and this was a college-educated woman that worked at ECC, it's in the record, she knew how to use that portal. If she went in there in those 3 years, that's a long time, and designated beneficiaries, then it changes the case 180 degrees. And tellingly, her will designated my client, the plaintiff, as the remainder beneficiary. And we have the testimony of my client that she was told she was going to be the beneficiary of the annuity. And we have the email from this August of 2021 saying, I made you the beneficiary. So we have every indication of the intent, but we just need the metadata to see if it got done. Now, I think our brief, and actually it's not my brief, my predecessor's brief, made clear that the dead man statute does not keep out the 2018 conversation with the plaintiff, the 2021 with text with the plaintiff. If there's any doubt that where we're defending against the summary judgment motion, the dead man statute is no impediment, I'll address that, but I think that's not a problem.
Counsel, your time has expired, so you should begin to wrap up.
That's why I talked about the dead man statute. Thank you for your patience,
Thank you,
Judge.
Counsel.
Thank you.
Morning, Your Honors. May it please the Court, Joseph Linares, Walsh, Pittsy, O'Reilly, Falanga, on behalf of defendant TIAA, first time in the Fourth Department. Very excited to be here, and I had the privilege of watching the swearing-in ceremony. It made my day. I take slight issue with counsel's representation. I recognize that he was not the attorney of record below and is the fourth iteration of counsel for plaintiff. What was produced at a good faith on the basis of a good faith production to move the case along to possibly foster settlement was the entirety of the file regularly maintained by TIA with respect to the Ms. Galvin's accounts. Okay, the metadata that he's referring to is not something that's regularly kept in the course of compiling an annuance file. It was also not requested in the the belatedly served discovery demands that only came out about a week.
What format was it produced in?
Excuse me?
Sorry, what format was that file, as you call it, produced in?
It was
Word paper.
It was hundreds of paper documents as well as 17 recorded calls between the decedent and TIAA.
And presumably somebody pushed the button to print out that file. And
Sure.
It
was transferred to me, and yes, sure.
Right, but so what they're looking for is the lack of the properties file, the metadata for those documents.
So what I believe counsel is looking for is the metadata that shows login activity to her online account. Whether or not that's something we can access, I'm not exactly sure, but there was no discovery demand for it in the lower court, and it's not part of the regularly maintained file. And this.
Sorry to keep.
No, go ahead.
Just like I'm trying to catch up here.
Understood.
So you're saying there was no demand for that metadata.
That's correct.
Therefore, there was no reason to address it in your production, either by producing it or saying we don't have it. Is that what you're saying?
That is correct. It's
so
not.
The record, does the record say something you just said here today, which is we didn't have it, or we don't necessarily keep it, or is that something you're just telling us today?
That's something that was addressed in the brief. The issue of counsel desiring the metadata did not come up at the lower court at all. It only was raised on appeal, and I would argue that he's then foreclosed for asking for it now. I understand that
just so I can clarify or understand the production of the documents initially right? The bulk documents, just to kind of, my understanding of the record, and correct me if I'm wrong, that was started before there was even a demand out.
That is correct, Your Honor.
In other words, there was an effort to try and get as much out and possible and to get things moving.
That is correct, Your Honor.
And then the demand came in.
The demand comes in a week before the summary judgment hearing. And again, that demand does not include a request for
That's at the
metadata.
time the summary judgment motion has been filed.
Correct.
Which then stays discovery.
Correct.
And so just before the hearing, the demand comes in. And that's the demand your opponent was speaking to when I was asking questions about, was there a demand?
Oh, I'd like to clarify that actually, because the demands that came in do not request metadata. They request still shots of an online portal, which is also something that's different than metadata. Metadata would show when a user accesses the file, when they click on this, when they whatever, right? That wasn't asked for. What was asked for, the production that we gave was comprehensive to all the belatedly served discovery demands, thankfully. The only thing that wasn't in there that I think was in the demands was screenshots of the portal, but that's something that plaintiff herself actually has access to. So I'd like to redirect some of my time to the call that counsel mentioned. And the reason that's important is because the allegations in this complaint are that in August of 2018, the decedent comes to plaintiff and says, I just made a change, as in something was one way and then it changed. I made a change to designate you, Miss Pandy, the sole beneficiary of these annuity contracts. This happens over ice cream, like allegedly on the heels of a meeting that did occur with her financial advisor. That is not how that meeting went. That's not how discovery shows that meeting went. And subsequently, there's a December 2018 call, right? In that call, the call is important because when they talk about the beneficiaries, and I think counsel was accurate in reciting the exact verbiage, and I know the call was produced as part of the record. It was one of many calls that were produced, the only call in which beneficiaries come up, right? The reason that's important is because when they talk about it, there's no, oh, wait, I thought 3 months ago we changed that to be Miss Pandy, or it was my understanding that this had already been changed, or something like that. That is completely absent. What's there is, yeah, I might take a look at amending those, but it hasn't tickled me yet, or something to that effect. So the call is important because it buttresses the plaintiff's lead claim here is that in August of 2018, the decedent went in and made a change. And again, what's important here is TIA is not like it's an insurance claim that's being denied and we get to keep the money that's not paid out in proceeds. We don't care who gets it. And quite frankly, we have no interest in being involved in these family dynamics, right? But what we do have is a duty to transfer the money based on the New York Estates Powers and Trust law and the case law to the beneficiary of record. The beneficiary of record in this case happens to be those that were designated and still surviving at the initial application process.
Well, actually, they're contingent beneficiaries, if I understand it correctly,
Right.
not the beneficiaries.
Well, that's correct, Your Honor. They're contingent beneficiaries, but that made by decedent who's signed the thing. So there's no change. The call shows that there's no change in 2018. So therefore, when it was advanced at summary judgment by counsel for the interveners, it establishes a prima facie showing that there was no change made in 2018. Then the narrative sort of flips like, well, maybe it was changed later. Maybe it was in 2011. And the only support that plaintiff was able to come forward with that a change was made, and excuse me, I know I'm talking fast, I'm trying to use my time efficiently. The only change that was made, the only evidence that was proffered in support of a change that happened in 2011 is a text message that in 2021, thank you. Is a text message that appears in the record at page 356. Now that's paraphrased and only one screenshot is used to oppose the summary judgment motion. But when read in context with the totality of that conversation, and by the way, what it says is changes are done, and that's this decedent's alleged words. We can't authenticate this, and it's, we have the benefit of Miss Pandy's subjective and interested view on that. But when you view that text message in the context of the greater conversation, which starts on the record at page 354, the changes are more likely referring to the will that they are discussing in time, where she's talking about, well, maybe you want to say this, or maybe you want to say this. And it even would suggest, and this is not my argument, counsel for interveners to make that actually what the changes were being made was working the interveners into the will in some substantial capacity. So the argument here is that there was no change effectuated in 2018 when plaintiff says with a definitive date that it happened on this date, and I know it happened on this date because she told me so. And whether or not she said that, I don't know. And it's also of no moment because the law requires substantial compliance with the beneficiary change protocol in order to change a beneficiary. That means that basically the decedent would have had to do everything in her power to effectuate the change, but for some reason was forestalled or precluded from doing so. And we don't have any evidence in the record that any change was attempted at all. So it's interesting here because the evidence of inaction is usually the lack of evidence of action, right? But here we actually have a phone call that post-dates when the alleged beneficiary change was made that shows that there was no beneficiary change made months prior. So it's sort of a unique scenario where there was a negative that was able to be proved, thankfully, in the form of a recorded call. Otherwise, we're dealing in a he said, in a decedent said, and this is what I understand it to be trial, and those aren't proper claims for trial. So if this is cases proceeded to go forward, I'm not sure what the trial is going to be about because we don't have anything close to substantial compliance. And I think the Hunnell case from this court that I cited is on point. Mere statements of intent, even to your spouse, that you're going to make them beneficiary, that doesn't carry the day. And there's other case law that would suggest, beneficiary forms were completed, signed, but were never tendered. Those aren't honored. Or even when there's a SDNY case, Sun Life 14F sub 3D 176, where the financial advisor was told by the contract holder, I want to make these people affirmatively, I want to make these people the beneficiaries, just like I had on my other accounts that are being transferred over here. The form was completed but not signed, and unfortunately and tragically, the decedent passed before her signature goes on to the piece of paper. And in that case, despite Sun's desire to effectuate the desires of the decedent, they're precluded from doing so because the foreman process was not followed. And it's very important that the foreman process is followed because it's an outward manifestation of the beneficiary's intent on who they want the money to go to, and it precludes, fraudulent claims of ownership, or the court from engaging in, quote, rank speculation as to what the decedent's desires were or were not. So again, belated discovery demands, discovery was stayed, the production was responsive. The affirmation that I made to the court was in the totality of the file, and it misses the mark on counsel's point, kind of misses the mark on, because again, this is fourth iteration of counsel. Oh, by the way, and what's also important is we did a whole investigation before this case even started to come to the conclusion. That was at the request of Pandy's first set of counsel.
In terms of structuring our thought process here, it looks to me we have to look first whether you carried your burden. You argue in your brief that you carried your burden with respect to the Brewer affidavit primarily, and maybe the phone conversation tape, right? That alone is what you say carried your burden on.
Correct.
That response, you would say they did not raise the tribal question of fact. Any of this stuff having to do with discovery was way too late and stayed at the time it was made in any event. So you would say that they didn't raise the tribal issue of material fact.
That is correct. And any attempt to amend your discovery demands through the appellate division is improper. I'm not sure if I have time left. I can keep.
You do not.
Okay. Thank you very much for your
Thank you,
It was a pleasure.
Good morning, Mike McGorry. May it please the court. I'm not gonna get too repetitive, but I think what's important here is what was alleged in the complaint. Pandy brings a complaint claiming that her aunt, Cynthia Galvin, changed the beneficiary or was somehow prevented from changing the beneficiary by TIAA and Brewer. Absolutely no evidence whatsoever submitted that she changed the beneficiary.
That's where I was with my question with your co-counsel there, your other counsel, is that, as you know, when you move for summary judgment, it's as though you're at trial and you go first, even though you're the defendant.
Right.
So whether or not there's any evidence supporting the complaint is sort of secondary to our analysis. That's why I'm kind of focusing on that. That is the extent to which TIAA met their burden and whether or not the plaintiff in opposition there to raise the tribal question of fact. I think that's our conceptual structure for addressing this appeal.
And I agree with you.
Okay.
So we met their burden because Richard Brewer said, and the records showed, that she had never changed the beneficiary first.
Well, it starts off, doesn't it, Mr. McGorry? It starts off with the records show that she had designated beneficiaries.
Right.
And contingent beneficiaries.
Right.
And then the next step is the record show that there was no change of the beneficiary?
Correct.
Okay.
So remember her complaint, her cause of action is that she changed the beneficiary. And we proved with admissible evidence that she never changed the beneficiary from the initial designation, one. And Richard Brewer testified that at no time did Cynthia Galvin ask him to change the beneficiaries, tell him she wanted to change the beneficiaries, want to change the beneficiaries. So that met our burden of shifting to the other side to say, where did she change the beneficiary?
And that's where I wanted to take you next for my benefit is the argument on appeal seems to be that in moving for summary judgment, the movement didn't overcome the affirmative defenses. But I couldn't find that argument below, that is in the papers below.
Right.
Am I missing something?
No, you're not missing anything, Your Honor. There's nothing in the stuff below. She brings the action saying I'm the beneficiary or he stopped me from being the beneficiary. We put in proof that she wasn't the beneficiary and that we in no way stopped her. And then we even put in the proof of the phone call. And the phone call was so huge because it's very possible that Ms. Pandy was told by her aunt in this conversation at the ice cream shop in August of 2018 that I changed the beneficiary.
So one of the issues you would say we need to look at is whether or not the plaintiff raised a tribal question of fact that was preserved.
Right.
Okay, we'll look at that, right?
I mean, even if these conversations occurred, they were lies because she didn't do it. If Cynthia Galvin actually told Colleen Pandy in August of 2018 that at the ice cream shop, I just changed the beneficiary, she didn't, which is documented by the phone conversation 3 months later with TIAA and with Richard Brewer that we have in the record where she admits that it hasn't tickled me yet. She's told exactly, if you want to change it, if you want to add beneficiaries, it's probably in the cave somewhere. And it was in the cave and she made the beneficiary. So she should know that at least there's beneficiaries in there. And the TIAA representative clearly says it's probably in the cave because it's in the cave. She says she doesn't want to make a change, which belies her claim that the Pandy's claim that 3 months earlier she had made the change. And then this text message from 2021, exactly as Mr. Linares said, it's about the will. There's a picture of the will in the text chain. There's a picture of the will that she's drafting, that she's having drafted. It's on page 355. Last will and testament of Cynthia Galvin. I made the changes. It's nowhere in this text message is TIAA or an annuity ever mentioned. Even if it was, she didn't do it. She may have lied to her again. But the point is that at no time was the beneficiary changed. At no time did TIAA stop her or deprive her of the opportunity to make the change. Pandy's own affidavit. My aunt was very adept on the computer. She went into the files all the time. She could see who her beneficiary was. She's an intelligent woman. She didn't do anything. And then this whole idea that, we need more discovery. That's what really bothers me. This case, this woman dies in 2021. My clients, Julia Coyle and James Galvin, should have had $1.2, $1.3 million back in 2021. Pandy petitions and says, I'm the beneficiary. They go through the whole discovery. They go through the whole file, everything. Takes over a year for them to say, you're not the beneficiary. My clients are the beneficiary. What happens next? 5 months later, Handy sues. And we're now into 2023.
We realized there was a period of time and there were many steps in the litigation process.
Right.
We don't have to go through all of those steps.
Here's what's not in the technical record. It's the delay. March 6th, 2024, this matter gets decided. 29 days later, an appeal's filed. 6 months to perfect the appeal. 5 months and 29 days. The appellant moves to extend her time. She's given extended time. The last day of the extended time, she files her brief. She does it improperly. Her case gets dismissed.
Mr. McGrory, I'm not sure where this is going, but I think
my client dies in the interim. And it's a delay tactic. Every time she had time to do something, the plaintiff took the longest day possible. And I have elderly clients, one of whom has died in the interim because of this delay, never got to have the benefit of the money that she was legally entitled to. And to send this back for discovery on something that is not going to, it's going to add 2 more years to this.
Counsel, we've got that.
Thank you.
Thank you. Case 352, Smith versus City of Buffalo. Mr. Lee, can you hear us?
Yes, I can, Your Honor.
Very good. I understand that the appellant has submitted. Is that right?
Yes. That's what shows up on the court's website. Yes.
Very good. Proceed.
Yes, I'll be brief, Your Honors. David Lee for the City of Buffalo. Supreme Court did not abuse its discretion when it denied plaintiff's motion for permission to amend the complaint. First off, if you take a look at the amended complaint, it does not show the additions or changes between it and the original pleading. That is in violation of CPLR 3025 subdivision B, and that alone provides a basis to affirm Supreme Court's denial of plaintiff's motion before you even get to the relation back doctrine. But in any event, the relation back doctrine cannot help the plaintiff in this case for a few reasons. First, as to the claims against Officer Nigrelli, there was no mistake when plaintiff failed to name Officer Nigrelli in the original complaint. And we know that because if you look at the notice of claim, Officer Nigrelli is named. So absolutely no mistake as to the failure to name Officer Nigrelli. Also, as to the 1983, the 42 USC Section 1983 claims against Officer Nigrelli, the plaintiff cannot establish the unity of interest prong of the relation back test because there's no vicarious liability between the city and Officer Nigrelli under Section 1983. So the proposed claims as to Officer Nigrelli should not be allowed to proceed. And the proposed claims as to the other 2 proposed new defendants, Officers DiSarno and Anderson, those claims should not proceed either because the conduct alleged in the original complaint had nothing to do with any negligence on the part, alleged negligence on the part of those particular officers. The original complaint focuses only on the conduct of Officer Nigrelli and has no theories at all about negligence on the part of those officers and failing to intervene and failing to protect the plaintiff. And lastly, Your Honors, as to the claims against Officers DiSarno and Anderson, which are based in negligence, those claims are insufficient, palpably insufficient. They can't proceed because if you take a look back at plaintiff's notice of claim, there was nothing in there raising a negligence theory as against those officers. So unless there are any questions, for those reasons, the city would ask this court to affirm Supreme Court's order.
Hearing no questions, Mr. Lee, thank you very much.
Thank you, your honors.
Calling next the case of 353 in the matter of James S. Mr. Riley, good morning, sir. Can you hear me okay?
I can, Your Honor.
And we can hear you just fine. We're all set, sir. Go right ahead.
Good afternoon, and thank you, Presiding Justice Curran. Nate Riley on behalf of MHLS, on behalf of James S. or JS, and may it please the court. This morning, I'll focus briefly on the weight point, and I believe I can succinctly cover that for Your Honors. The lower court's decision was against the weight of the evidence, where it found support only in loose, equivocal, or contradictory evidence personified by the OMH doctor's testimony that JS remained likely to commit another sex offense, despite the OMH doctor's own actuarial assessment indicating no more than a 19% likelihood of recidivism when compared to offenders in foreign countries utilizing that same actuarial tool, the VRSSO. The statute deliberately chose the word likely to commit sex offenses under Section 1003E, and the VRS scoring and many other factors in this particular case simply do not support the conclusion that JS remained likely to commit another sex offense. The statute reserves confinement as a DSORC for the most extreme cases involving the most dangerous offenders, and this court taught us in George N. that JS's past conduct, even if characterized as heinous or repugnant, is only the beginning and not the end of the court's analysis, which instead looks to the current dangerousness of JS under this court's decisions in George N. and Groves. And the evidence here simply did not support current dangerousness. As the independent expert opined, JS, due to his libido-reducing medication, his advanced age, progressing in treatment to the cognitions core group, and exhibiting a lack of sexually acting out for 2 decades prior to the court hearing, is simply no longer dangerous or likely to commit a sex offense as those terms are used in the statute. And with that, I'd welcome the court's questions.
Hearing none, Mr. Riley, we're all set, sir. Thank you.
Thank you very much. We ask this court to reverse and remit for the implementation of a regimen of cyst for the 68-year-old with intellectual deficits who lacked any record of any new offenses or sexually acting out in the past 2 decades and has remained confined either in Docks or Stark since 1997. Thank you.
Okay, we'll hear from the respondent now.
Good afternoon, Your Honors. William Hayes on behalf of the state. Supreme Court's order of continued confinement is amply supported by Dr. Fuset's opinion that James S. remains too dangerous to be released into the community. As Dr. Fuset explained, James S. has not adequately progressed in treatment and therefore lacks insight into his offending conduct, which is reflected in his persistent sexual fantasies about children. He continues to violate facility rules, which is consistent with his longstanding aversion to supervision, and he lacks a plan to ensure his safe reintegration into the community.
What do you think about the argument from the appellant here this morning that he highlighted on with respect to the percentage risk of recidivism?
Sure. So I understand there are a couple different arguments that I understand him to be making, which is first that the risk of recidivism here is not sufficiently high. Again, it's an above average risk of recidivism based on the doctor's estimates. And it's well supported by the other quantitative evidence of the record. I know in his brief, James S. also argued that something greater than a 50% chance of recidivism is necessary. That's not supported by the text of the statute, not supported by the case law. Even Dr. Singer didn't submit an actuarial risk assessment. So if such a greater than 50% chance of reoffending was necessary, you would imagine that that would have been in the record. Contrary risk score. And also Supreme Court had good reason to discount Dr. Singer's opinion because just 18 months prior, he opined that James S. was too dangerous to be released into the community. And then just a couple brief responses to counsel's argument this morning. Supreme Court didn't just rely on past behavior in determining dangerousness. James S.'s behavior in the past is consistent with his behavior now. And as to his,
Not every petitioner we see in these Article 10 cases is as forthcoming as the petitioner was here. I mean, is that a factor that we should consider in his favor?
forthcoming in his treatment.
Forthcoming in what he's thinking, what he's feeling, his communications.
Sure. So I think Dr. Fuse acknowledged that Mr. S is making progress in treatment, which includes being open at times with his providers. She also highlighted that he does not participate in all of his treatment. He doesn't go to certain treatment at all. He participates more in general groups as opposed to those that are specifically addressed at his mental abnormality. And he's not fully honest with his treatment providers. So even if he has some sort of commendable progress in treatment, that's not sufficient to overcome his otherwise deficient performance and progress. If there are any other questions, I'm happy to answer them.
No other questions, Counsel.
Right, thank you.
Thank you. Case 354, Kelly and Moody versus Snap-on Incorporated.
Good afternoon, Your Honors. May it please the court. It's our position that the trial court erred and abused its discretion in issuing a carte blanche denial of access to an entire Medicaid ledger outlining treatment by John Moody that encompassed the period of his entire lifetime following an in-camera review. In that same in-camera review, the court reached a decision that records and information identifying pre-accident treatment for things such as cognitive, psychiatric conditions, substance abuse treatment records, or medical treatment records relative to the body parts at issue were discoverable. They were deemed material and necessary. That aspect has not been challenged. That is still the rule of the case here. However,
Isn't your argument necessarily assuming that the court didn't make a comparison? Didn't compare the billing records with the other records, didn't do like a side-by-side to make sure that the billing records don't reference something that, oh, gee, we don't have that provider. It assumes that, right?
Your Honor, that's exactly our argument, that there's a Medicaid ledger that includes treatment and references providers specifically relative to a history of polysubstance abuse disorder that Mr. Moody had documented in his post-accident records. He was on treatment for Suboxone, for cocaine abuse. There's also toxicology reports from the post-accident assessment that found that there were substances in his system. Those records have not been part of and were not produced as part of the Medicaid billing records. Those are what we're missing. And the court did not go through and do any kind of review of the Medicaid ledger, it appears. Instead, the judge said that presumably, because it covered the entire period of the plaintiff's lifetime, it included childhood illnesses. Presumably, to me, it seems to indicate that there was no review. Assuming it did include childhood illnesses, which were deemed by the court to be irrelevant, those could have been redacted out. That was not done in this situation. So we have records that identify his entire mental substance abuse treatment and medical situation, and we have no actual review of those records in a case involving a severe traumatic brain injury, cognitive deficits, a quadriplegic, who is alleged to be totally disabled, complete loss of career, with a demand for $50 million. So we've got a ledger that has potentially responsive information in it and would identify those providers that we know he treated with before the accident for, again, substance abuse that's documented in his post-accident records, but we don't have access to that information and thus cannot request it. There's an argument that's made that, well, we got all of the records from the in-camera review other than the Medicaid ledger, so no harm, no foul. Those were records for providers that were, and it's specified in the order, known or discovered at the time of the in-camera review. That's not his entire medical history. We don't know his entire history because we don't have access to this Medicaid ledger. We have never been given anything from his pre-accident treatment. We know he's got pre-accident treatment for substance abuse. The court has deemed that to be discoverable, but then they didn't take the next step, which is go through the ledger, identify those providers he saw for that, and disclose that to us. So again, our argument is really that there was no exercise of discretion. There was simply a decision that because presumably there may be something irrelevant, that they weren't going to give us access.
Also, remind me, relative to the record in this case, was there a specific request of the court upon doing the in-camera review that the court identify for you as part of the discovery, maybe not the medical billings, but the identity of the providers of the medical services so that you could follow up with your own investigation?
Yes, Your Honor. So there was originally an order dated September 10th of 2024 that specifically stated that all of the records, literally all of the records for any known providers in this case, were to be subject to the in-camera review, including the Medicaid, for the purposes of, again, identifying the substance abuse treatment records, the medical records relevant to the body parts at issue, which are frankly most body parts, and any kind of cognitive or psychiatric conditions. There was a protective order, in fact, by the plaintiff to cross-move for a protective order on that same documentation.
But I guess I want to be really clear on my question so I get a clear answer from you.
Yes.
Was there a specific request to the court when they did the in-camera review of the records that were produced, that both parties knew these records were being produced to the court, that the court go through any Medicaid billing just to identify providers that didn't otherwise provide records?
Yes, that was part of.
So there's a specific request of the court, and your argument now is the court did not do that work in the face of a request.
Yes, and at the same time found that the information regarding that substance abuse history, the mental health history, was all relevant to this claim for a traumatic brain injury, found that to be all discoverable, disclosed all of the actual treatment records that included that information. Not all of the providers, because again, we don't know all of the providers. Plaintiffs, in fact.
Part of your, I mean, unless I misunderstand, is part of your argument, you know all of the providers if they were identified through the Medicaid records.
Exactly.
And then you could then, on your own, once you've identified that they were providers, send out your authorizations and your requests and get those records.
Precisely, because those are the records that the court has deemed discoverable. Those are the records that have not been challenged, that have been found to be material and necessary, but we don't have that information from the ledger to then make that step to request those providers.
Did you say in the beginning of your argument that since the time you've now been going through the medical records that you do have, that you found other providers and you've made requests, I assume, directly to plaintiff's counsel saying, oh, gee, we found a new doctor, we found a new provider, something like that in the records that you suspect are also in the Medicaid billing records, but you don't know because you haven't seen them, but you've made that request and you're getting those records. Is that true that that's happened or no?
Certainly, we have found additional providers referenced in records that we have then been able to request. So part of, for example, the in-camera review, we got records from a primary care doctor. Those records referred to some other providers, but we don't know if those are all of those providers.
But when you realized that oh, there's other things here, did you go back to the court and say, Your Honor, we'd like to renew our motion regarding the Medicaid billing records? Turns out we're finding some missing records here and there. And did you let the court know that maybe can you take a closer look?
We have not made a motion to renew. No.
That would be faster and easier than having us do this process and send it back, right?
It may have been to ask the court to make that review again. But no, we filed the appeal instead, and the appeal has been pending. And we have.
Excuse me, I think I'm really behind here, but do we have the Medicaid billing records that were submitted to the court for in-camera review in our record?
No, it is not part of the record because we do not have those records.
But so submitted, is there any dispute that they were submitted to Supreme Court for in-camera review?
No, there's no question that they were submitted to the court as part of the in-camera review. They were reviewed by the plaintiff's counsel. Plaintiff's counsel then prepared a redacted version that redacted all pre-accident treatment. It included all of the post-accident treatment. The court issued the decision of the January decision on the in-camera review. After that, we received a copy of the ledger that has everything pre-accident redacted. The post-accident was not redacted. That was from the plaintiff. And that is where that has stood.
From reviewing the briefs, I thought it was just on the line in the order. The basis of your belief that the court really didn't do a careful analysis below was based on this one line about, presumably the childhood illnesses aren't relevant. I forget the line, I don't have it in front of me, but I thought that was the basis of it. I never saw anything in the briefs. Did I miss it? That there were these other records that now revealed new providers? Like, that's all news to me. Was that in the brief?
So in the brief, it was that at the time that the motion was made, we had information in post-accident records that had been disclosed by the plaintiff that he had pre-accident treatment for substance abuse treatment. We did not have information as to the providers that he had that treatment with. So we knew he had treatment that was relevant before this accident, but we did not know who. Since this appeal was filed, we have, in certain circumstances, been able to determine that because they were referenced in other records. Our concern is we are now more than 6 years after, post-accident. We are talking about, actually, we're more than 8 years post-accident. We're talking about a period of time that many times these records have been no longer available. So if, let's say, he has a provider that might include the reference to a different provider, we don't know that because that record might no longer be around. So that's our concern. The Medicaid ledger, which we know exists, we know it covers the entire period of this person's life because the court has indicated that to us in its decision. We know that it may presumably include irrelevant childhood illnesses, but there was no redaction of those irrelevant childhood illnesses. Instead, it was just...
If they're irrelevant, are they discoverable?
No. And we're not asking for a completely unredacted Medicaid ledger. We are asking that the court simply go through and redact what is deemed to be irrelevant, but provide access to what the court has already determined to be discoverable, which is substance abuse treatment, treatment relative to cognitive, psychiatric, or mental health, and treatment relative to the body parts at issue in this case.
And did you ask the other side to provide you with that information so you could subpoena it yourself?
Yes, and the subpoena was served with records to the court pursuant to the judge's request to do an in-camera review of everything. The ledger was with the court. The plaintiff's counsel reviewed the ledger. They redacted off everything that was pre-accident, and they gave us only what was post-accident treatment. So that is why we're still missing pre-accident treatment relative to, again, those things that the judge has already found to be discoverable.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. John Collins, on behalf of the plaintiffs. Preliminarily, the record on appeal and defendant's brief suggested that the Medicaid records and billing records that Supreme Court reviewed in camera were not provided to the court this court for in-camera review. And in response to Justice Curran's question, counsel just confirmed that. I submit that, in the absence of those records, so that this court could determine whether or not the trial court committed a pure abuse of its discretion, the appeal should be dismissed. Because
if I understand correctly, we're being asked to produce those records reviewed in camera without our ability to review them ourselves.
That's right.
Okay.
And when,
So let me ask you this, assuming that we did that.
Yes.
Right? We said, look, at the record's not complete enough for us to do an appropriate appellate review of this case, the appeal dismissed. Would there be anything stopping your co-counsel from going into court before Judge Caruso and saying, look, since your order, we've uncovered that there are other providers that we didn't have access to, and we'd like to renew our application to Judge for you to give us the information regarding the doctors in the Medicaid, the names at least, or identity of the doctors that treated the plaintiff under the Medicaid documents, the billing documents.
Well, I don't think anything would stop a party from making a motion. How Judge Caruso received that, treated it, and resolved it.
Yeah, no, I'm not asking for you to, to indicate, but there's no procedural reason why that request couldn't be made, say under the CPLR, making that application.
Offhand, I can't think of any unless there's some provision, and I don't have the CPLR in front of me. A time limit contained within the re-argument section governing such motions. Whether that would apply, that would be something I'd have to look into. So I can't.
Yeah, I'm not even sure if that it'd be a re-argument. It could be just a fresh application.
True.
Yeah.
But I think, counsel could have, and I think was obligated to arrange to have the records that she acknowledges were before the trial court for its in-camera review, likewise transmitted to this court for its in-camera review. And I know that Your Honor, Justice Ogden, Justice Del Conte, not too long ago had a case, Shelkoff versus Berkowiak, which I could cite to the court in a post-argument submission if you want, where it was very similar in-camera review, and the court said, if we don't get the records, we've just got to dismiss the appeal. How can we determine whether there was an abuse of discretion or not? But on the merits, if the court concludes that it can reach them, I submit that the trial court, which obviously had broad discretion in resolving discovery, did not clearly abuse it in this case. As defendant acknowledges, they received subpoenas in response to a court order, and the subpoenaed records were given to the court. After reviewing them, defendant acknowledges in their brief, Judge Caruso directed production of unredacted copies of all of the pre and post-accident medical, mental health, and substance abuse treatments. So they clearly have the records that they were seeking in this case. Defendants also acknowledged that they received, following the entry of the order at issue on appeal, a ledger containing a Medicaid ledger billing record containing post-accident treatment only, with all pre-accident treatment redacted. And the court, I think in the trial court, didn't simply say, well, because there's probably some childhood illnesses in there, they're not entitled to any of it. What the court actually said is, there are also Medicaid billing records which are sought that go back to the plaintiff's date of birth. Plaintiff is 36 years old currently and was 30 at the time of the accident. The court does not find billing records, which presumably include child illnesses, to be relevant to the current claims. He didn't say just because they presumably include childhood illnesses. That was kind of an aside, but he said the billing records are not relevant. And I think that was influenced by the fact that he had already given them everything else they want in terms of records, actual medical records, not just billing records that they asked for. That, I think, was within the court's discretion, and it was not a clear abuse of it. But as I said, this court being unable to compare the redacted versus the unredacted records, it's really, I think beyond the scope of the court's, power review to say, anything other than that the court was justified in doing what it did not abuse its discretion.
Thank you, counsel.
Thank you.
Case 355 in the matter of Sean Mahoney versus the Village of Springville. Proceed, counsel.
Good afternoon. Lana Ivy, Lippis Mathias, LLP for the Village of Springville. This is an Article 78 proceeding where service was untimely by several months. And we submit that the trial court improvidently allowed the petitioner additional time to serve. There were two major issues with the decision. The first is that there's case law, including from the Court of Appeals, that says complete lack of diligence by a petitioner is essentially dispositive. Yes, there's discretion, and yes, there are multiple factors the court can consider, but lack of any diligence is dispositive and should not permit additional time.
Should we credit any diligence to the fact that it was a professional processor that was hired?
No, Your Honor. And the reason is, first of all, the affidavits of service on their face were deficient, right? Because it said town clerk and you're trying to serve a village. So it clearly was not the mayor or the village clerk.
Also included the word deputy.
Right, and it was a deputy. So on its face, it was deficient. But I would say the sequence of events after the first service attempt is actually more compelling, because we raised the service issue on February 4th, 2025. In filed papers, we specifically explained that the wrong person was served at the wrong address, not associated with the village, and exactly why it was improper. It had names, it had dates, it had the address, the proper address. And nothing at all was done in response to that for months, right? So the lack of prompt attempt to remedy the situation, I think, is very compelling here and goes to the lack of diligence. The first time they said anything at all about it was on April 24th, and it still was not a request for additional time. All that happened on April 24th is they doubled down on the improper affidavits of service, and they said, well, you know what, the court can also non-protonque do something about it if it wants. Again, that's just not reasonable diligence. The actual motion for additional time was made on June 16. That's more than 4 months later. So I think the diligence or lack thereof speaks for itself on this record. And you do have Slate v. Schiavone, that's a Court of Appeals case that says that reversed for abuse of discretion due to lack of diligence. You also have this court's case, Janiga v. Town of West Seneca Zoning Board, and the timing there was extraordinarily similar to this one. The extension request came 4 months after the statute of limitations lapsed. Here it was.
Counsel, that the diligence factor, probably weighs against the petitioner here, of course.
Right.
But the question is also, I think the court indicated there really is no prejudice. I mean, and the reality is it was within a day or so, or the same day that the petition ended up in the right hands. Your client was well aware of this litigation and actively was engaged in the litigation. So, doesn't that weigh in favor of the petitioner here?
No, Your Honor, and I'm glad that is my second topic, is the prejudice, because an extension of time can only be granted if there is no prejudice. So that is, and we believe there is prejudice here. Not only has it caused additional fees, because they didn't just remedy the situation, they fought it for several months, or they ignored it, and then they fought it and they doubled down on the improper affidavits. But more importantly, this is an Article 78. So it's supposed to be an expedited proceeding to start with. The relief requested includes reinstatement and back pay. So delaying this.
Well, it was a combination. This was a combination Article 78 civil rights claim here. There was other relief that was requested as part of the initial pleading.
Right, and then, but the main relief requested has to do with reinstatement and back pay. So there is prejudice because both of those are much more difficult to grant or work out as the time passes. But again, if you look at the case law, it's not an accident that all of the case law they cite to say, well, there's no prejudice. Virtually none of those cases are Article 78 cases, and the only one that is Article 78, they denied and dismissed the petition. So I think the fact that it is supposed to be an expedited proceeding is important here. Lastly, the third error in the decision is that there was really no consideration given to the fact that this is not a meritorious claim. The burden is on the petitioner to show that there is a meritorious claim here, and this is a former employee with a lengthy disciplinary history. The misconduct is substantial for which he was terminated. And, you know, he failed to exhaust the administrative remedies. I mean, there are several grounds that are dispositive on the merits here, and there is no discussion at all in the order of the merits. If there aren't any questions, we ask that the court reverse and dismiss the petition.
Thank you, counsel.
Good afternoon, Your Honors. John Manier from Ralph Larigo's office. I'm here on behalf of the respondent, Sean Mahoney. The lower court properly granted the order extending Mr. Mahoney's time to serve the appellants pursuant to CPLR 306B simply because Mr. Mahoney showed good cause and the court found the extension to be in the interest of justice. And those are the two bases in which 306B applies. And I think it's really important to go through the timeline here. So actions commenced within the 4-month statute of limitations under CPLR Article 78. Subsequently thereafter, on 12/20/24, Mr. Mahoney hires a professional process server. He goes to serve the village board of trustees, and he found out subsequently, he serves the neighboring town of Concord. Now, it's important to understand the town of Concord actually includes the village of Springville. It's wholly inside of the town of Concord. Josh Allen could throw a football from the village of Springville.
That's not the issue. The issue is where the buildings are located and their addresses.
Very well, and it is, Judge.
So I mean, I guess what you're taking the position that the process server lied on the affidavit of service as to where the service was completed.
That's exactly what Mr. Mahoney did. So the process server went in his affidavits of service. He noted that he served the quote deputy town clerk at the proper address of the village.
But he wasn't there. She wasn't there at the address. She wasn't at West 5th Main Street.
And that was subsequently found out thereafter, once we received an affirmation from the village, from the appellants in this case, and we only received that affirmation on June 2nd of 25. In that affirmation, you have the deputy town clerk from the town of Concord indicate, I am not an employee of the village. I was not present at 5 West Main Street. Immediately after I received these papers, I turned them over. I called a clerk typist from the village and I turned over the papers, the suit papers, the petition, the notice of petition complaint, all over to the village. So once
That's the document of evidentiary value that you're referring to in your briefs.
Yes. And so once we received that non-hearsay affirmation and substantiation from the appellants in the case, we immediately inquired at the process server. And in fact, we obtained an affirmation from the process server indicating and conceding he may have gone to the wrong location. Once we had that, we immediately brought a motion less than approximately 2 weeks thereafter, seeking to extend our time to answer under 306B. But even before that, when it was raised in the answer, and let me back up. So not only did the appellants appear in the case, they appeared and asked for an extension of time to submit their answer. As was stated by the appellants here, this is an expedited proceeding. However, the court does take into account the voluminous submissions and all the issues that need to happen in an Article 78. That said, the court granted them an extension of time to serve their answer.
From the initial return date.
Exactly.
There was an initial return date in January and it didn't come on until May or something like that.
Exactly, Your Honor. And so we come now to 6/25. Okay, that's when the answer was submitted by the appellants. And that was the first time that we see the alleged defective service. And so in our reply, timely on April of 24 of 25, approximately 2 months thereafter, which was also set by the lower court, that time frame. We're not delaying anything. This is something that was set by the lower court.
Now we can agree with opposing counsel that it doesn't really look like a request in the reply, but the court took it as one. That's what the court based this decision on page 4 and 5 of the court's order.
And it was, Your Honor, respectfully, it was a request. It was not a motion, but again, this is an expedited proceeding. The appellants have indicated that they moved to dismiss in their answer, and they essentially did. This is a very truncated
7804, the CPLR allows for that.
It does. And so in our reply, we did raise and we asked the court to grant the extension of time pursuant to 306B. It was expressly stated in our reply, but we also indicated that we were in the alternative relying on the valid affidavit of service because again, we didn't have an affirmation, non-hearsay document stating that service was defective. Once we received that, within 2 weeks thereafter, we moved immediately to extend our time. And that's the timeline. And in fact, the court rendered its decision on June 18th. Okay. And it took into account our affirmative request in our reply to extend the time to answer. And it laid out the basis for doing so, but it did rely on that request and in fact mooted our motion under 306B. Under 306B, it permits the court to grant an extension for one good cause or in the interest of justice. And that is in the sound discretion of the lower court. That's from this court's decision back in 2022 from Megan versus Mansour. Good cause, you must show due diligence. The process server, we heard a process server, a professional process server, goes to the location and he serves a deputy town clerk. Deputy village clerk, deputy town clerk, they're permitted to accept service on behalf of the clerk of that municipality. And that's expressly clear within the village law, town law, including the public officers law. So serving a deputy is not improper or lack of diligence. It's permissible under 311 of the CPLR. It's permissible to serve a municipality with a deputy clerk. And it's
But you don't get
noted.
the right municipality, don't you?
You do, Your Honor, but it's when you have small towns, and practically speaking, when you have small towns that we're dealing with in this situation, and you have the village of Springville, which is located wholly within the town of Concord. And in fact, we are now talking about, again, a stone's throw away a different building. Anyone without a GPS, I know we all have cell phones, and I know we have we have all those, the technology to be able to locate it. It can happen. 20 years ago, I'm sure this was commonplace. Today, it shouldn't happen. But it happened here. And as soon as we found out the mistake, we remedied that mistake and we asked the court for the relief that we needed to be able to extend our time to serve. So we didn't sit in our hands. This isn't something that's latches. We immediately moved once we had that affidavit. And so not only is there good cause, but the court also found it was in the interest of justice to extend the time. And there's some considerations that were set forth in Batara versus Colage 22 AD 3D. It's a second department case out of 23. And in fact, and the Court of Appeals, Leader versus Maroney, Ponzi, and Spender. That's a 2001 case. That sets forth the specific analysis for the trial court to weigh and balance certain things in consideration of what is the interest of justice. First, the petitioner's diligence. Second, the expiration of the statute of limitations, the merits, the length of delay in any service, the promptness of a request for an extension of time, and also any prejudice to the respondents. And so we've already discussed diligence, the expiration of the statute of limitations. Statute of limitations was 4 months. When we filed this action in December, we were at that 4-month statute of limitations. So when we first received any notice of defective service in the answer, which was 2 months thereafter in February, we couldn't refile. Even if the court even if we wanted to, we couldn't reserve because we didn't have an extension of time. It was already past the statute of limitations. And in fact, this court in Bustler versus Corbett indicated that if you have a statute of limitations that has expired, it actually works in favor of the party trying to reserve, of the petitioner. And so that's one factor that weighs in the favor of Mr. Mahoney. If you go to the merits, the most blatant...
So you should begin to wrap up.
Very well, Judge. I'm going to touch on this and then I'll ask the court to affirm. The most glaring issue, one of the biggest glaring issues, is the fact that village trustee Schuster, who was a complainant in a portion of the charges against Mr. Mahoney, was a person who was not only involved in the investigation of those charges, but who rendered her credibility in voting on termination of Mr. Mahoney. There's case law directly on point that a board member, trustee cannot participate in any vote that would terminate an employee when their own credibility is at issue as the complainant in the case. That alone shows there's meritorious claims here. Based on that, Judge, and all the other reasons cited in our brief, I respectfully request that the court affirm and remit the matter for further proceedings.
Thank you, counsel.
Thank you.